Okay.
There you go, right there. There's the agenda.
Okay, this is Tina. I think we are just about ready to start the meeting. We would like to remind everybody, because we were not able to vet all of the people on the telephone, to please, if it's your turn to speak, to dial *9 if you're on the telephone, or raise your hand in Zoom, and we will then unmute you and you'll be able to speak. Again, that's *9. And thank you.
Good morning. Can everyone hear me?
Yes.
Morning, Jim.
Great. Good morning. Sorry for the technical difficulties. I know we're 10 minutes late, so I apologize for that. It shows that I'm Terry Upton. I'm actually not. Terry is allowing me to borrow her computer due to technical difficulties. So anyway, with that, Tina and Director Young, are we ready to begin the meeting?
Yes.
Okay, very good.
Yes.
I'll call the meeting to order. Tina, could you call roll, please, of the tax commissioners?
Commissioner Littman? Commissioner Littman?
Present.
Commissioner Bursey?
Here.
Commissioner Brown? Commissioner Brown?
You're on mute, Randy.
Apologize for that. Present.
Commissioner Kalesis? Commissioner Kalesis?
Tina, he'll be a few minutes late. He'll join us later.
Thank you. Commissioner Wren?
Present.
Commissioner Rigby?
I'm here.
Commissioner Witt?
I am here.
And Chairman DeVoe.
Present.
Thank you.
Okay, at this time, we'll invite public comment. If you'd like to provide public comment, please raise your hand by dialing *9, and the department staff will unmute your line. And if you could, please state and spell your name for the record. So at this point, Tina, I'll let you handle the public comment portion and unmuting people.
Thank you.
Tammy Stinger?
Why are you on?
Yes, I'm here.
Thank you.
Thank you.
Okay, no, they have.
Ms. Stinger, go ahead and provide your public comments. You're limited to 3 minutes. Go ahead.
All right. The reason I am here today is requesting waiver of penalties and interest on our sales tax accounts for state of Nevada due to the COVID-19.
Ms. Singer, Ms. Singer, this will be handled inside the agenda, the consent agenda, so you don't really need to have public comment. It's basic public comment
Okay.
on something that may not be on our agenda, but we'll handle it in order, please.
Okay, thank you.
Thank you. Tina, is there any other public comment?
Yes. Just one moment, please. No. Try, see if he would like. Go ahead.
Faye, if you have public comment, you can go ahead and unmute your phone at this time.
Nobody contacted me. We're here for Leo Schoenfeld. And I just wanted to let you know we were here. I'm here. I'm his wife and he doesn't know how to do this. So I'm on for him. He's with me though.
Thank you.
So is there any public comment that's not related to the agenda items that we'll be discussing today? Any public comment unrelated to the items that are on the agenda? Go ahead, Tina.
Mr.
Hello,
Katz?
Yes, can the commission hear me?
Yes.
Yes.
Thank you. Thank you very much. I am on the agenda. It's item 5D. However, I had a generic introduction to make. I thought this might be the appropriate time, but if you feel to wait until the item's called, I can do it then.
Mr. Katz, we plan on giving you about 20 minutes during your presentation. Would that be sufficient to handle that under the agenda item?
Yes, I think it will be. Thank you very much.
Okay, thank you, sir. Tina, any other public comment unrelated to items on the agenda?
Yes. Phone number ending in 646. You may now provide public comment. Please, phone number ending in 646, dial *6 to unmute your telephone.
I'm apologizing. It's Rosalie Bordelev here. I was just unmuting so that I can speak later if needed. I have my phone muted separately.
Thank you.
Any other public comment?
I do not see any other public comment at this time.
Okay, thank you. Director Young, would you please administer the oath for those who plan to testify before us today?
Yes. Good morning, Melanie Young, Executive Director for the Department of Taxation. For those that are going to be testifying today, by testifying in this meeting today, you are attesting that you will swear to tell the truth in your proceedings here today. Thank you.
Okay, very good. Next item on the agenda is the meeting minutes. We have 2 sets of minutes to approve, June 25th and July 31st. Are there any additions, corrections, or a motion to approve both sets of meetings?
This is Commissioner Wren. I'd move to approve.
Commissioner Rigby, second.
Okay, I've got a motion and second. All those in favor, please signify by saying aye.
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 Anyone opposed? Okay, minutes are approved. Next item on the agenda is the consent calendar. Anything under paragraph 3. Is there any commissioners that would like to pull any agenda items for further discussion?
Mr. Chairman, it's Commissioner Brown. I would like to pull items B10 and B21, please.
Very good. Are there any other items that we'd like to pull? Okay, I'll entertain a motion to approve the remaining agenda.
So moved.
Commissioner Witt, second.
Okay, I got a motion and second to approve the consent agendas, everything under paragraph 3. All those in favor, please signify by saying aye.
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 Anyone opposed, same sign. Consent agenda is approved. Okay, let's go back to the items, Commissioner Brown, that you'd like to pull. Go ahead and call those out for me, please.
Thank you, Mr. Chairman. It's item B10, Orca Digesters, Inc. And item 21 under Wildwood Guitars. I really have the same question on both items. I don't know who from the department is going to respond, but in both instances, it's on the agenda for waiver of penalty and interest. And when you look at, for instance, on page 89 is Orca Digesters. When you add the sales and use tax number, the penalty and the interest, the taxpayers paid it in full. So I'm not tracking why it's on the list for a waiver of penalty and interest. And the same is the case for item 21, which appears on page 190 of the package. If you add the $16,484.34 in tax, the related penalty, and the related interest, it equals the amount that the taxpayer paid in full.
Director Young, do you have,
This
is Melissa
is
Gardner on?
I was going to say, this is Shelley Hughes, Chief Deputy. Commissioner Brown, on those instances, sometimes the taxpayer pays the amount in full. So the penalty and interest will be paid, but then they request a waiver because they voluntarily have come forward and reported the amounts. So once the commission approves, then they will be issued a refund for those amounts.
Okay.
And we will waive.
Okay. I appreciate that. That helps. Can I ask one other question in general? I noticed on for instance, look at the last one. It's on page 190. I noticed this on quite a few of them. It's the department approved the waiver in October of 2019. And so we're in August of 2020, and there's several of these that are that way. I'm just curious, it's 10 months before the tax commission sees it when the department had already done the work and approval back in October of last year.
I'm not sure if Melissa Gardner is on the phone. She is in the Reno office, and I know that there's been some difficulty with them being able to get on the Zoom. I'm not sure the reason for the backlog. I do know that at times we do receive a lot of these voluntary disclosures, and so staff has to go through each individual one to approve them. And then, with COVID, we have this last several meetings, we have not had any voluntary disclosures on the agenda. So these would have been probably seen earlier in the year, or before you earlier in the year. So I can get back with you after speaking with Melissa to let you know, the exact reason why there's almost a year before it comes before you.
Okay, I'd be interested.
Hi, Shelley. This is Kayla Yost. I do have someone raising their hand, and I'm not sure if that's Melissa Gardner. Would you like me to ask?
Yes, please.
Phone number ending in 101. If you are Melissa Gardner, can you please unmute your phone?
Dial *6 to unmute your phone.
This is Melissa Gardner.
Melissa, were you able to hear Commissioner Brown's question?
You can hear me now?
Yes, we can.
Okay. As far as the time, for Wildwood Guitars specifically, I had attempted to get that one on the agenda the prior meeting, but unfortunately the taxpayer didn't receive the notice, so it wasn't able to be on the agenda. And at times they do take a little bit longer to get on the agenda. If the tax is short paid, we have to wait for that payment to come in. So there can just be various reasons. And of course, with the COVID, that has slowed things up a little bit for some of the taxpayers as well.
Thank you.
Okay, any other questions? Randy, could you make a motion to approve those final two items in the consent agenda, please?
Yes, thank you, Mr. Chairman. I would move to approve item B10 and B21.
Commissioner Witt, second.
Okay, I've got a motion by Commissioner Brown, seconded by Commissioner Witt. All those in favor?
Aye.
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 Anyone opposed? Same sign. Okay, those items are approved. So for anyone that's on the meeting right now, if you've got your agenda in front of you, anything that's under the consent calendar, paragraph 3, all of those items have been approved, and you're welcome to stay on with the meeting, or you're welcome to carry on with your day. Okay, Director Young, the next item on the agenda, Division of Local Government Services.
Thank you. For the record, Melanie Young, Executive Director for the Department of Taxation. Moving on to item for the Division of Local Government Services, item A, the consideration for approval of a reappointment to the Appraiser Certification Board for Kelson Powell. And I would like to turn the time over to Local Government Services staff to present. Thank you.
Good morning, Mr. Chairman, members of the commission. This is Jeff Mitchell for the record. Before you today is the approval of reappointment to the Appraiser Certification Board. Under NRS 361-221, the Appraiser Certification Board consists of 6 members, 3 of whom must be chosen by the Assessors Association and 3 of whom are appointed by the Nevada Tax Commission. Mr. Kelson Powell requested reappointment to the Appraiser Certification Board, and his term would begin October 1st, 2020 and expire 2022. Mr. Powell came to the department in 2016 from the Maryland Assessors area. He has served as a property appraiser 2 here with the Department of Taxation since that time. He holds a Master's of Business Administration, has taken multiple classes within the state of Nevada on management and supervision. He has served on the Appraiser Certification Board as the vice chair for the last little bit, and I believe he is available on Zoom if you have any questions, but the department would recommend reappointment to the Appraiser Certification. I am open to answer any questions if you have some.
Thank you,
Good morning,
Mr.
this is
Mitchell.
Commissioner Wren.
Go ahead, Commissioner Wren.
Thank you. Good morning, Jeff. Thank you very much. Yes, if he's online, that'd be great. The basic question I had is he shows that he was with State of Maryland 2014, 2016. Did he have appraisal experience before that time? And if he's online, I'll let him answer that.
Is he raising his hand?
He is not.
Please
Jeff,
dial.
do you-
Oh, here he is.
Okay.
Kelson?
Sorry.
Mr.
Kelson, if you can hear, can you please dial *6 to unmute your phone?
Did you press on
Mr. Powell?
Commissioner Wren, could we get back to you on that? It seems like we're having some technical difficulties, and we'll send a answer to your question through the department, if that's all right.
Absolutely, not a problem. Thank you very much.
Okay. Any other questions of Mr. Mitchell? And it doesn't sound like we've got Mr. Powell on the phone. Any other questions of the staff? Would I entertain a motion to approve Kelson Powell for reappointment to the Appraiser Certification Board?
Commissioner Berthe moves to approve the appointment of Kelson Powell to the Appraiser Certification Board.
Commissioner Rigby, second.
I've got a motion by Commissioner Berthe, seconded by Commissioner Rigby. All those in favor, please signify by saying aye.
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 Anyone opposed? Same sign. Congratulations, Mr. Powell, if you're on the phone. Director Young, next item on the agenda.
Thank you. Again, Melanie Young for the record. I'm Director for the Department of Taxation. Moving on to the next agenda item, which is the approval of a revision to the 2021-2022 Assessor's Handbook of Rural Building Costs, Section 1, page 18, as authorized under NAC 361.128 subsection A. And the department has staff from local government services, either Jeff Mitchell or Cheryl Erskine available. Thank you.
Hello, this is Cheryl Erskine with the Department of Taxation Local Government Services. I'm appearing before you today to seek your approval of an update to Section 1, page 18 of the 2021-2022 Manual of Rural Building Costs, which was approved by this commission in March. County assessors are required to use standards adopted by the Nevada Tax Commission when valuing property in the state of Nevada. As part of those standards, NAC 361.128 specifically provides for a manual of rural building costs used for the valuation of agricultural type buildings and improvements like barns, equipment sheds, bunkhouses, corrals, etc. Most costs in the Manual of Rural Building Costs are derived from the current Marshall and Swift commercial manual and are updated in an Excel spreadsheet, which is then linked to a Word document to provide a printed and published manual for the assessor's use. The tables on page 18 of Section 1 did not update correctly because of a broken link, which wasn't discovered during the review prior to the Tax Commission's approval in March. This update was sent out to the assessors on April 9th, 2020 for review and comment. We didn't receive anything back from them. We therefore respectfully request approval of the update to the Manual of Rural Building Costs as presented. I'm happy to answer any questions you may have.
This is Commissioner Wren. I would move to approve the revision as made.
Second by Commissioner Witt.
Got a motion by Commissioner Wren, seconded by Commissioner Witt. Is there any other discussion?
Commissioner Lippman, I assume that the link has been fixed now?
Yes, it has. The way that the links between Excel and Word is kind of an interesting concept. And so I did go in and I did fix that, yes.
Thank you.
Mm-hmm.
Any other discussion? Okay, very good. I've got a motion and second. All those in favor, please signify by saying aye.
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 Anyone opposed? Okay, motion passes. Director Young, the next item on the agenda.
Thank you. Again, Melanie Young, Executive Director for the department. Going on to the next item under this agenda, taxpayers' appeal of the treasurer denial waiver of penalty and interest per NRS 361.4835. The first item under this topic is Glenn David Swiarski And we have Jeff Mitchell here to present. Thank you.
Okay, Tina, if you could unmute, and I'm sure I'm not saying his name correctly, Spirarski. Could you please unmute him? This is his appeal, and I'd like him to make his presentation.
Just one moment, please. Thank you.
Thank you.
Mr. Saworsky, if you're on the telephone, please dial *9 now to raise your hand. Mr. Saworsky, if you're on the telephone, please dial *9 to unmute your telephone. Chairman DeVold, this is Tina Padovano. I did try to call Mr. Saworsky on last week, and there was no answer and his voicemail was full, so I'm not sure if he plans to attend or not.
Okay. Very good. Mr. Saworsky's reason for the appeal, it appears to be that he did not receive his tax bill. And according to NRS 361.480, failure to receive an individual tax bill does not excuse the taxpayer from paying in a timely manner. So from my perspective, I'm not sure what else we can do. I see Mr. Mitchell, are you the one that would like to discuss this any further? Is there anything else that I don't understand?
Thank you, Mr. Chairman. Jeff Mitchell for the record. No, I believe that you fully understand the issue before you. I do believe that the Washoe County Treasurer is available as they were the respondent, but their packet is also included in the packet that was submitted to the Tax Commission for review.
Okay, I don't know that we need to discuss this any further unless any of the other commissioners have a question of the Washoe County Treasurer or staff.
This is Commissioner Brown. I would move to deny the appeal.
Commissioner Lippman, seconds for the record.
Thank you. I've got a motion by Commissioner Brown and seconded by Commissioner Lippman to uphold the denial of waiver of penalty and interest for Glenn David Saworsky. All those in favor, please signify by saying aye.
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 Anyone opposed? Okay, denial is upheld. Director Young.
Thank you. For the record, Melanie Young, Executive Director. Moving on under this same agenda item, item number 2, which is 877, or let me try that again, 887 Trademark LLC. And we do have from the department, Jeff Mitchell. He is available. Washoe County is available on the phone. And I see the taxpayer is also in the Zoom. So.
Okay, Tina, could you please unmute the taxpayer representative for 887 Trademark?
One moment, please. Thank you.
Thank you.
Mr. Chairman, this is Jeff Mitchell. If it is okay with you, I'd actually like to provide a little context on this appeal in the introduction.
Please. Go ahead.
The appeal before you is the first of its nature, but it falls under NRS 361-4835 as the authority. The LEAD program, or the LEED program, was enacted in Chapter 701A for energy-related tax incentives. This program provides for partial abatements of property taxes on properties with buildings that meet LEED standards. This property was granted an abatement starting July 1st, 2012. but the property sold to a different owner on November 5th, 2015. It was purchased by 887 Trademark LLC. On April 9th, 2018, the director of the Office of Energy, who oversees the LEAD program, notified the taxpayer that it ceased to qualify for the abatement, effective January 1st, 2017. Because of the phrasing of 701A 1110 subsection 8, if a partial abatement terminates pursuant to this paragraph, the owner of the property to which the partial abatement applied shall repay to the county treasurer the amount of the exemption that was allowed and interest that accrues. And so the Washoe County Treasurer issued a bill in October for $106,431.20. The taxpayer appealed because they were not the owner of the property from 2012 to 2015. They do not contest the partial abatement that was the repayment from 2015 to 2018. And so that is why the difference of the number on the topic, which I submitted there, is the tax amount from 12 to 15 and the interest that accrued during that time. This was originally sent down to the administrative law judge to determine jurisdiction to make sure that we could hear the case and that we have the authority. Her opinion was that under NRS 361-4835, which is the normal route for penalty and interest, and the standard for that, for granting the appeal or granting the waiver, is that the taxpayer must demonstrate that its failure to timely pay the taxes in question is the result of circumstances beyond the person's control and occurred despite the exercise of ordinary care and without intent. And I appreciate you letting me provide a little bit of context, as this is a unique appeal, and I just wanted to frame it and see if there's any questions before we hear from the respondent or the petitioner.
This is Commissioner Wren.
Go ahead, Commissioner Wren.
Thank you, Jeff. That was my big question. I do understand the LEAD program. What I didn't get out of everything that I read is, why did they lose their certification? Typically, the LEAD is a construction type generated observation for energy efficiency. And even though the property sold, why did they lose the certification? I don't understand that.
And that might be oh, sorry.
I'm sorry, are you able to hear me okay? This
Yes,
is Robin. This is Robin with 887 Trademark. And prior to us.
Can you do me a favor, Robin? Could you spell your first and last name for me, please, for the record?
Yes, ROBIN Curtis, CURTIS.
And your function with 887 Trademark, what's your capacity?
I am the Director of Asset Management for the company.
Thank you. Go ahead, please.
Thank you. When we purchased the building from WMS Gaming, the building was mostly vacant when they used it. And then whenever we took over and purchased the building, we became 100% occupied with two large gaming companies, and their energy usage was a lot more than what was allotted by the LEED certification. We tried to figure out ways that we could still remain under the LEED, but we just couldn't back down on the amount of power that these two companies were using with all their gaming equipment and all their programming and laptops and whatnot.
Okay, that answers my question. Thank you.
Thank you.
Mr. Chairman, Commissioner Rigby, I do have a question, and it might be for Jeff. This is a unique circumstance where the property changed hands and the original owner received some tax abatement, and the new owner then has lost the certification, but they're not only having to pay back what they were abated, but what a previous owner was abated. And that's just because that's what the law says, and this circumstance doesn't seem to have been anticipated. Is there a way that, and I know that the staff is kind of stuck with the regulations the way they're written, but is there a way that we can determine that if this is the entity, their rebatement, their portion of the abatement would be lost, not the prior owner's abatement having to be repaid by the current owner?
This is Commissioner Wren. That kind of follow up to my question. I was thinking also, it seems to me like that the current owner should only owe the abatement since they owned it. And if the prior owner was in violation, we should go back and get money from them. But they weren't in violation. It didn't change until the new ownership started. So I agree with Commissioner Rigby.
And again, Commissioner Rigby, I wouldn't want to encourage entities who are about to lose their lead designation to then have a quick sale in order to avoid having to repay it, even a sale within a related party, or somehow be able to go around the law to not have to repay it. I think we'd have to watch for that. But in this circumstance, it doesn't look like that was the situation. So I think you would have to look at it on a case-by-case basis. But in this case, I would think that they should only be accountable for the portion of the abatement that they actually received.
Mr. Mitchell, do you have any comments regarding this topic?
Thank you, Mr. Chairman. Jeff Mitchell for the record. That is a perfect summation of the issue that is at hand. And I wish I had a great recommendation one way or the other on this one. Perhaps if the petitioner and the respondent can present their issues and their arguments, some further information might come to light, which would help guide on this distinction here. But my apologies, I don't have a great answer or response to that question which is posed.
Is Robin Curtis still on the phone?
Yes, I am.
Okay, Ms. Curtis, I just have a quick question for you. So it sounds like this was an empty building. They were complying with LEED certifications. And then you purchased the building, and then you had 2 tenants occupy the building. Am I correct?
Actually 3.
3 tenants. And these tenants used a extraordinary amount of power. Is that all 3 of them had the same issue?
Two of the 3, and the building still maintains some of the benefits that gave us a LEED certification. Our only issue was going over on our power usage. Yes.
And that's what tipped you over on the LEED certification, and why you no longer qualify is you had 2 tenants that used an extraordinary amount of power. Do I have that right?
Correct.
So did you, were you compensated through those leases somehow that you can recapture those costs? I mean, obviously nobody was forcing you to sign leases with those 2 tenants. I'm just kind of curious, did you compensate yourself somehow once you figured out that you couldn't recapture that tax abatement?
At the time of the leases, we had not. One of the tenants does pay their percentage share of the power within just the electricity in the building. The other large one does not. But we definitely will be revisiting that come lease renewal time.
Because it doesn't sound like there's a chance that they're going to lower their power costs, and that LEED certification will be forever gone.
Correct.
Increasing your costs going forward.
Correct.
Gotcha. Okay. Are there any other questions by any of the other commissioners?
Do we know what the
Hold on for a second. Commissioner Brown.
Thank you, Mr. Chairman. I just, I'm not a lawyer, but reading the NRS, I don't see how we have any option other than to require the repayment. And I think it's an unfortunate situation But also, I think, generally in the world, the costs are paid. And the legislature's given us the rules, and I just don't see any other option. And it is unfortunate, though.
Commissioner Lippman, for the record, I would also say that when any buyer buys a property, there's typically there should be, for both parties, due diligence and efforts looking into what potential costs are down the road. And so this should have been something that was known and then negotiated, as the chairman was saying. It should be part of the negotiation. And I'm sorry if they didn't or weren't aware of it, but we don't want to create a situation, as Commissioner Rigby was saying, that would invite a transition of ownership to try to do some self-dealing and avoidance of this rule.
This is
Commissioner Wren. I'm sorry, Commissioner Wren, did you have a comment?
Yeah, I guess a question for 887 to follow up with Commissioner Lippman's. 887, were you aware of the lead abatement when you purchased the property, or were you surprised when you learned about it?
We knew that we had the tax abatement from having the LEED certification. After we received our loss of LEED tax notification, after we did some research, then we found out that we should have been notified that if we lost the LEED certification, that we would be on the hook for those charges. We were not notified of that by the prior owners. I do wish that perhaps with the LEED certification, that maybe if we had needed to sign a form upon the purchase of the building stating that we understood that if we lost LEED certification, that we would be we would have to pay for those prior fees. I'm not trying to put blame on anyone. I'm just saying maybe moving forward, a form like that could keep people from trying to do a quick sale, losing the LEED. But we did not know that we would be responsible for the fees until after the fact.
Okay, and a follow-up, everybody has been talking about your building being vacant when the prior owner was using it. Was it vacant the fact that it didn't have tenants, or did you remodel it for your new tenants?
The prior owner was a owner user. So they were only using a portion of the building that they owned the whole building, sorry. We purchased it and turned it into a multi-tenant building. So I'm sorry, I think I lost my train of thought there. So it was the way that we had changed it and the occupancy that made us lose it.
Okay, so when you did your extensive remodeling, did you look into the certification or have discussions with the LEED program as to what those modifications would do to your certification?
We did not. We made sure that the tenants were still connected to the solar power systems and the backup generators and the UPS systems. And we maintained the energy management system throughout the building. And we did not speak to anyone from the LEED program. Unfortunately, this was our first time owning a LEED certified building, and we were not well versed in it, I suppose, and that would definitely be our fault there. And it's not a mistake I will make in the future.
Okay, Ms. Curtis, I agree with Commissioner Brown. I've read the NRS, and I'm not sure we've got a lot of wiggle room here, but I think one thing that you did say, I think is important. I think the disclosure of the LEED certification, your requirements going forward from the commercial real estate brokerage community would be helpful to everyone that purchases a LEED certified building to identify costs that could impact you. I mean, obviously, you probably didn't have the leases in tow when you purchased the building. Maybe you did, but that research would have been very valuable, and you could have discounted the purchase price based on the recapture of those tax abatements. And had you known that, I guess, I think that's one of the things that I'm thinking we should discuss with the commercial real estate community more than anything else, that there's hidden costs there. But again, I agree with Commissioner Brown. I'm not sure we have a lot of wiggle room here. It's denoted by the legislature, and I don't think this was something that was completely beyond your control had you known. So is there any other comments by any other commissioners?
Mr. Chairman, can I just get a clarification? Because in the packet, if this is quoting the statute exactly, it says under NRS 701A 110 paragraph 8, if a partial abatement terminates pursuant to paragraph B of subsection 7, the owner of the property to which the partial abatement applied shall repay to the county treasurer. So the owner of the property is the current owner to which the partial abatement applied, not the previous owner who it previously applied to. It looks to me like it's talking in current language, but I could be wrong. I don't know how it's been interpreted in the past.
The way I read 701A.118 subparagraph 8 is that you're required to repay the county treasurer the amount of the exemption that was allowed before the date of termination of the lead certification. So that's why the Washoe County Treasurer, I think, is following the guidance for years 2012 and 2015. I know it's unfortunate. I totally agree, but I think we're kind of in a box here with this specific regulation, unless another commissioner reads that differently.
May I ask a question?
I'm sorry. Is that Ms. Curtis?
Yes, I apologize. May I ask a question?
Please. Yes.
If we end up with, needing to pay back all the abatement, if there is any way we could maybe receive some relief on the interest, as we did go ahead and pay the tax payment, just to show that we, fully understand everything that was going on. Maybe if we could just possibly receive some relief there, that would be really appreciated.
Could I ask Rosalie Bordelove, Rosalie, does the tax commission have the power to rebate accrued interest on this, or should that be an offer and compromise situation, either with Washoe County Treasurer or with the Department of Taxation?
Hi, Rosalie Bordelove here. Let me look at that just a little bit. Can I give you an answer in a few minutes? I'm looking at it right now.
You may.
Commissioner Lippman, for the record, I'd just like to say that typically in any purchase sale agreement, the seller needs to disclose material issues. I mean, any typical boilerplate language would include that. And so while 887 might not be able to get relief from the tax commission, I would certainly have them consider whether they can pursue the seller. So there could be, the law could provide some sort of relief for them if the seller didn't provide this rather material issue.
Okay. Any other questions or comments?
This is Commissioner Witt.
Commissioner Witt.
I just a thought on the LEAD program. Normally, it is perceived by potential developers, and that status is achieved because it gives you a standing in the the nature of the building, and it is normally an asset. My thought is that if one or the other of these tenants that has this high energy use that makes or creates the violation was to leave, then what happens? Because then the lead status would come back, or would it? Do you see what I'm saying? It's almost like it reminds me of another case that I was reading, where there could be a refund then due. Let's just say the tenant's changed and that energy use goes down. So it would seem that lead needs to be the entity that revisits their thought process and would perhaps allow for a growth accommodation where other environmental benefits could be enhanced if you were to run into an energy consumption limit from a previous approved lead status, if that makes any sense.
Commissioner Witt, one of the things I was thinking is I'm not sure if there's a way for 887 trademark to recapture those costs, those unknown costs within their individual leases with the two entities that are causing the problem. Obviously, that would be, as a landlord, I think I would attempt to make sure that my lease is written in a fashion where I can recapture unforeseen costs, based on a percentage of ownership of the tenancies. So I don't know, there's probably a couple of options associated with this is what I'm thinking. But as a landlord, I would try and recapture it because the tenant is the one that's actually causing this.
Right. Exactly.
Rosalie, do you have an answer?
Yeah, in looking at it, I think I agree with you that I'm not sure that the tax commission has the power to grant an abatement on this one because the statute does say the owner shall pay interest. And if that interest is not being paid to the department, the person who is being paid to might have the ability to forgive some of it. I also agree that there is potential recourse for the taxpayer here against the prior owner of the building. While this is an issue that they may not have been aware of, it's something that was in the law. And so it's not something that could not have been found had there been people with the adequate expertise advising on the sale. And that's an issue between them. That contract, I don't know what it said. That is completely not a Department of Taxation issue, but it is true that this law existed and the fact that this could happen existed at the time of this sale.
So it sounds like to me, Ms. Curtis could pay the tax in full, ask for an offer in compromise from the Washoe County Treasurer, and we'll let them negotiate that piece of it rather than make a decision here. I think we've got one option, after I've read the NRS standing. I don't know that we've got another option according to the regs. Is there any other comments or a motion? Hearing no comments, is there a motion? I'm sorry, Commissioner Rigby.
I would move to uphold the treasurer's denial of waiver of penalty and interest for 887 trademark.
Commissioner Wren, second.
I've got a motion by Commissioner Rigby, second by Commissioner Wren. All those in favor?
Aye.
Aye.
Is anyone opposed? Ms. Curtis, thank you very much for your time. I'm sorry, and good luck with the Washoe County Treasurer. I hope they will take care of you on the interest side.
Sorry, they had actually stated that they couldn't do anything and that I had to go through the Nevada Department of Taxation. So
Okay.
I thank you for your time.
Yeah, thank you, and I appreciate your commentary today. Okay, let's go ahead with the compliance division. We've got a denial of offer and compromise. I think we've got one of those, and then we'll take a break. Director Young.
Thank you. Director Young, for the record, this is for the Compliance Division, the department's recommendation to the Commission for a denial of an offer and compromise pursuant to NRS 360.263. The taxpayer is Eddie Hernandez, and the department has Adrian Roberts Larson on the line to present. Thank you.
Good morning, Mr. Chairman and members of the Commission. This is Adrian Roberts Larson for the department. Eddie Hernandez has submitted an offer and compromise to settle debt on Sanyo LLC. The business operated from 2010 through 2012 as a Quiznos sandwich shop. The offer is to pay $200 on tax of $19,000.26 and total debt of $36,741.74 with interest calculated through the end of August 2020. The debt is the result of returns filed without remittance. The stated reason for the request based on data to collectability. Mr. Hernandez states that the business did not have the means to meet its tax obligations and subsequently closed. He supports his 4 children and wife on a single income and that the necessary living expenses exceed his current income. Based on analysis of the supporting documentation provided, sufficient grounds have not been established to recommend approval. Specifically, monthly bank statements reflect an excess spent on eating out and over $600 in payments for payday installment loans. The bank statements do not reflect any expenses for monthly bills. Finally, Mr. Hernandez is a young man with future earning potential, and the offered amount of $200 is unreasonable. It should be noted that the department received the offer and compromise request from Mr. Hernandez in 2018. In September of 2019, the department mailed a letter to him with a counteroffer to pay the remaining tax balance and monthly payments of $200. The response due date was October 1st, 2019, and no response was received from Mr. Hernandez until February of 2020. Enclosed in the packet that you have are multiple letters that were received from Mr. Hernandez, in which he cited USC Title 31 and states, among other things, no phone calls, please. He does not understand, and he denies the liability owed. However, Mr. Hernandez signed payment agreements and guarantees in 2011 and 2013 for all periods owed and acknowledging the debt. The debt is secured by a personal lien. Additionally, he further acknowledged the debt in his offer and compromise letter from 2018. Therefore, it is recommended that the Nevada Tax Commission deny the offer due to the reason of doubt as to collectability for sales use tax periods ending February 28th, 2011 through December 31st, 2011, April 30th, 2012 through July 31st, 2012, and September 30th, 2012 through November 30th, 2012. I'm happy to answer questions from the commission.
Thank you, Mr. Roberts Larson. Is Mr. Eddie Hernandez on the telephone?
Mr. Hernandez, if you're on the phone, please dial *9 to raise your hand. I don't believe he's on the telephone, Chairman DeVol.
Okay,
Mr. Chairman.
Yes.
Mr. Chairman,
Commissioner
Rigby. We're being asked to make a decision on denying an offer in compromise. There's no offer in our packet. There's no supporting documentation. There's reference to bank statements. There's no bank statements in there. There's no information on him having made the offer, or just it's quoted, but there's nothing in there. There's quite a bit of, it was a little bit of a throwback to the 90s, those frivolous tax arguments that people tried to sell back then, which there's an IRS website page, irs.gov, of frivolous tax arguments, and you can read how they didn't work and they've been debunked. I mean, so it was interesting that someone's still trying to make that argument, but there's nothing in the packet for us to approve or deny, in my opinion, because there's no offering compromise or supporting documents to look at.
This is Adrienne Roberts Larson, if I may. The documents that you're referring to, Commissioner Rigby, are supplemental. They should have been supplemental to the actual offer and compromise packet. And in what you're referring to should only be the letters. Tina, are you able to help out with this by chance?
Hi, Adrian. The packet that I received that I supplied to the commission, it contains 34 pages, including the recent correspondence from Mr. Hernandez. It was basically a NTC memorandum and a spreadsheet, and then the correspondence. So I don't know that it was supplied in the packet that I received.
Commissioner Rigby, would you be agreeable to continuing this item until we get the full package? Maybe continue this until our next meeting and then supply us with the full package, and then we can vote on. You know, on the surface, it sounds like there's you know, a possibility to collect significantly more than $200 on a tax bill that's $19,000, and with penalties and interest, it's over $37,000. So I'd almost like to see what his capacity is, and maybe that's really what we're missing.
I would move to table item 5A, I'm sorry, Eddie Hernandez, to a future agenda so that we can see the offering compromise and the supporting documentation in order to make an informed decision.
This is Commissioner Wren with a, I'll second, but I have a question also. She indicated.
Could I get a second on the motion before we start the discussion though?
Oh, I did. I said I said that. Second, but with a question.
I'm sorry, I still didn't hear you.
Yes, I second it.
Okay.
Now I have a question.
Proceed.
So when you bring the packet back to us, you indicated that you had a personal guarantee on it. I'd also like to know if we have any other liens, garnishments, or anything else other than just the financials. So this is a heads up. I'll be looking for that. Thank you.
Thank you.
Okay, I've got a motion and second to table this agenda item 5A1 to the next tax commission meeting with additional information. All those in favor, please signify by saying aye.
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 Anyone opposed? Okay, very good. Let's go ahead and take about a 5-minute break. If we could try and keep it to 5 minutes, and then we'll reconvene. I've got 10:11, so if we could be back at, I'm sorry, 10:12. So if we could be back at 10:16 ready to go, I'd appreciate it. Thank you.
a temporary office. But anyway, so.
Okay, let's go ahead and get started again. Do I have everyone back? It looks like I do. Yes. Director Young, the next item on the agenda.
Thank you, Chairman. Melanie Young, Executive Director for the Department of Taxation for the record. Moving on to the next agenda item, which is the consideration of the department's motion to dismiss the taxpayer's appeal and taxpayer's appeal of the administrative law judge decision pursuant to NRS 360.245 and NAC 360.175 for Jose Ricardo Tapia, AKA Jose Richard Tapia. The department has Peter Keegan from the Attorney General's office available. Thank you.
Thank you. And Tina, do you know if Mr. Tapia is on the telephone?
Mr. Tapia, if you are on the telephone, please dial *9. And he is on the telephone. We're unmuting him now. Thank you.
Thank you.
Good morning,
Mr. Keegan.
Commissioner.
Mr. Keegan,
Good morning,
are you on the
Commissioner.
phone? Go ahead.
Yes, this is Peter Keegan. Chairman DeVold, can you hear me?
Perfectly.
Thank you very much, Mr. DeVold. Good morning, Commissioners. This is Peter Keegan from the Nevada Attorney General's office on behalf of the Nevada Department of Taxation. We filed a motion to dismiss in this appeal of the responsible person determination for Mr. Jose Richard Tapia, who I believe is on the telephone. Our motion to dismiss, as you may have already reviewed, stems from the original deficiency notice in this matter dating back to May 31st of 2016. Through a long process, unless the commission would like me to go through each individual procedural item, this matter has now reached the responsible person determination phase. The Tapias, specifically Mr. Tapia, Mr. Jose Richard Tapia, was identified as the sole responsible party for the deaths of Gato Malo Inc., doing business as Carson City Harley Davidson. Mr. Tapia has filed an appeal of the responsible person determination that was filed on December 6th of 2019 with the Nevada Tax Commission. There has been no communications from the Tapias, despite attempts by the Nevada Attorney General's office to reach out regarding the status of the appeal. There has been no opening brief filed by Mr. Tapia in conjunction with his notice of appeal. So pursuant to Nevada Administrative Code 360.175, which requires an appellant to file an opening brief within 30 days of a notice of appeal, the Department of Taxation has submitted this motion to dismiss. We have not received any correspondence in my office or at the Department of Taxation, to my knowledge, from the Tapias, but I believe, as I stated earlier, that Mr. Tapia is on the phone.
Okay, thank you, Mr. Keegan.
Thank you.
Thank you, Mr. Keegan. Mr. Tapia, this is your appeal. Go ahead and make your case, and please state and spell your name for the record.
P-I-A. Are we, hello, we okay?
Sorry, would you do that again? You cut off early on, so go ahead and state your name and spell it for the record. And then go ahead and make
It
your
is
case.
Richard Tapia, T-A-P-I-A, for Gato Malo Inc. I just want to hear an acknowledgement that you're able to hear me.
Mr. Tapia, we're having a really hard time hearing you. Could you get closer to the microphone or
Let me see if this works. Is that
speak?
better? Should I call in?
You should call in. We really can't hear you at all.
Okay, I'll dial it right now. Okay, I'm right here in Zoom.
Tina, is Mr. Tapia now on the telephone?
Mr. Tapia, have you dialed in yet?
Yes, I have. It's asking me for the different ID numbers.
Well, we can hear you good now.
Can we in there? I tested everything. Should be okay. I'm sorry for that.
If you're on your telephone device, if you've dialed in, please dial *9.
No, I have to unmute him. Mr. Tapia, what is the last 3 digits of the phone number?
Mr. Tapia, are you still there?
If you're on the phone number ending in 012, if you dial *9, it'll unmute your phone. *6.
It's *6. Mr. Tapia, if you're on the telephone, please dial *9 to raise your hand. And if you've done that, dial *6 to unmute yourself.
Hello. There we go.
Yes.
Okay. Sorry for that technical difficulty there. Let me
No,
turn off my
I think we've
computer.
experienced it all day long. So go ahead, Mr. Tapia. Thank you.
Yeah. Thank you. The overall issue on when we first started this at, I'll call it an adventure, boy, had been that we had always agreed that we had owed, that Carson City Harley Davidson / Guatemala Inc. had owed $220,000 in back taxes, which was the amount that was put aside during the sale of the business. And so during that time, they, meaning the Department of Taxation, did the audit. And one of the main problems or the main corrections that needed to be done was that the Department of Taxation has put all the vehicles that we sold as wholesale to the auctions as items that need to be paid, hence bringing the overall total of what is owed to over $2 million. From 220, we went over to $2 million. And so in this overall issue, that was the main part, going through attorneys and going through the whole process, that even though it was shown that these items, the sale items, were not part of the resale or taxable items, they still have put it on to the taxable amount. Again, when the business was sold to Michael A. Hull, they were aware that $220,000 in taxes were still owed of sales taxes, of which $200,000 had been withheld from the sale to pay the Department of Taxation. And the holder of that $200,000 is still Michael Hull, which they have not released to me. I have informed them to release it to the taxation board, since we have always agreed that that is the amount that is absolutely owed. In addition to that, we were denied access to a lot of the documents that we had in storage there at at the Carson City location. After having the attorney obtain the files, we then submitted everything that we did have to the department. One of the items that were always sent out were the documents that were produced from the Talon Harley-Davidson system. Talon is the brand name of their computer system that they use to distinguish or to do their accounting and basically be able to communicate with the manufacturer financially, that is. So with that, that's a system that's used by most Harley-Davidson dealers. And I say most because there are an option of that system and another system, which I apologize, I don't remember the other one since this is the one that is recommended. So we've been using the system since 1998, which we have always used to produce the sales tax and tire tax calculations. You know, as the department was going through the audit, they were questioning the reports that were submitted, primarily because they said that they were just questioning it, which they wanted me to produce new documents. And I did not have new documents. Hence, the previous person's point that we did not respond to his communication. We did respond to the communication stating that we do not have new evidence. We have the consistent, continuous evidence of how the documents were prepared, who prepared them, and how it was overall generated. So my summary would be that I am requesting that we, and I apologize, can you hear me? Because I am getting a phone call from somebody in Las Vegas. Is that?
Yes, we
Are we
can
still
hear
good?
you. Yeah, we can hear
Okay,
you
very
perfectly.
good. I just wanted to make sure that here I am talking and nobody's listening. Sorry about that. And so to summarize, there has been throughout this whole process items throughout the audit that were mistakes and corrections that needed to be made on behalf of the Department of Taxation, which they have not done. They have not addressed those corrections. Their statement is that I need to submit new documentation, but yet it's the same issue that has not changed. The reports do not change. The numbers don't change. You know, it's the interpretation of what they're stating is incorrect. And again, this is through attorneys that I have hired and so forth. So to summarize, I would like to request that the department waive the penalties and the interest and to correct the taxes owed, which should be $220,000, not the amount that has been stated on that.
Thank you, Mr. Tapia. Really, all that's in front of us today is to decide whether or not you're a responsible person. It sounds to me as if you are. I would encourage you to, beyond this meeting, engage in an offer and compromise conversation with the Department of Taxation, and that would solve several of these issues. And I think that's really where we're going here. You know, appealing the administrative law judge's decision that you're not the responsible person doesn't sound correct to me. But like I say, I think the offer and compromise process is one that you should engage in with as much interest as possible. And we're willing to listen to that offer and compromise at a later date. Does that sound like something that would solve your conversations?
Yes, that's definitely a piece of the puzzle that, of the things that I have discussed, of the items that which we have agreed or that we know of the taxes that should be owed, as opposed to all the interest and penalties and other items that are not part of this conversation. As far as being the responsible party, that part is, should not be the corporation still be the responsible party to be paid. And I realize that as a officer of that corporation, I am the one who's physically doing these meetings / creating the payment for this. But as far as being a responsible party, shouldn't it still stay with the corporation and still stay with the business itself?
Yeah, but you're the sole officer of the corporation, is what it looks like to me. So, okay, let's do this. Is there any other questions of the staff or Mr. Tapia at this time?
This is Commissioner Rigby. It looks like there are 2 items for us to move on item B with the semicolon. So are we going to take them separately?
No, I'd rather take them together on this topic. So do you have some questions on the second item outside of the responsible party?
No, but if I remember correctly, we did hear this taxpayer, and the taxpayer came in person in Carson City, and the window of time of the audit had closed, but we then claimed that he had documentation and he had boxes of records and files, and we kind of stretched the rules a little bit to say, okay, we're going to give you some time to go back and provide those records to the department to see if it makes a difference in audit results. And it appears that either they weren't provided or it didn't make a difference in the audit results. But we had allowed that window of time for that to take place. Babysitting my grandbaby today. And it just seems like that we're down to the decision point, and I'd be willing to make a motion unless there's other comment.
I have a comment on that.
Go ahead, Mr. Tapia.
Yes, during that report that you're referring to, or the time that we had met, that the Department of Taxation, what their point was that they wanted to see new documents. They wanted to see additional proof, additional items. And my point to them was there is no additional items. There is no additional proof. It is your reading of the original reports that were the issue. And I even got third party, meaning from the auction houses, documentation of the vehicles that did go through there, and yet they still did not act upon those. So their point was, again, to summarize, they wanted new information that does not exist. It was like what you had mentioned. It is the same information that they were not willing to review again and again, stating that they have already reviewed it. And so anyway, which I agree, which we have already reviewed it, but their interpretation was incorrect.
Mr. Keegan, do you have a response?
Yes, thank you, Chairman DeVolt. This is Peter Keegan for the Nevada Department of Taxation. If the department, if the commission members could turn their attention to what I believe is page 388 of 392 for the Jose Richard Tapia file that we are on. That's the department motion to dismiss. I don't know if yours is a separate file for this item. If it isn't, I'll just take you through briefly. My point is, as Commissioner Rigby has identified, we've gone through the audit, an ALJ determination at a contested hearing where Mr. Tapia was represented by counsel back in August of 2017. Decision was issued. There was an appeal to the Nevada Tax Commission. It was heard, wherein the Nevada Tax Commission, specifically, I think Commissioner Kalestis was concerned about a single issue, which was the wholesale of a number of the motorcycles in this instance. And there was legal argument submitted as to whether or not there needed to be wholesale resale certificate for the wholesale auction houses to confirm that those bikes were not just delivered based on the Excel spreadsheets, which were submitted by Mr. Tapia on behalf of Gato Malo. They, that is the corporation, Gato Malo, confirmed that they would submit that type of documentation within 90 days. They were given 90 days to do so. They did not submit the additional documentation, which they said they had. During that period, the Tapias, Mr. Jose Richard Tapia and his, which I believe to be his wife, filed Chapter 13 bankruptcy. There was a letter submitted to Gato Malo's sole members, Mr. Tapia and Ms. Tapia, on October 19th of 2018 by the department requesting that they submit the documentation requested by and stated that they did have concerning the wholesale bikes to the Department of Taxation within 14 days. No documentation or correspondence whatsoever was received. A follow-up letter was then sent to the Tapias on behalf of Gato Malo on December 7th of 2018, wherein this matter was referred back to the Nevada Tax Commission for a request that the underlying administrative law judge determination finding and upholding the deficiency notice in full be upheld based on the lack of documentation submitted by Gato Malo. Going through the procedural history further, the Nevada Tax Commission did hold a hearing on December 27th, 2018, and there was a decision letter issued on January 25th of 2019 that upheld the underlying decision of the administrative law judge against Gato Malo. Skipping through a few items there, the Department of Taxation then pursued Mr. Tapia in the Chapter 13 bankruptcy by filing a motion for relief for stay, which was granted by the bankruptcy court in September of 2019. On October 24th of 2019, a responsible person determination letter was sent to the Tapias. On November 13th of 2019, a hearing was held, wherein there was a decision issued on November 19th of 2019, where the administrative law judge found that only Mr. Jose Richard Tapia was liable for the deaths of Gato Malo. On December 6, 2019, Mr. Tapia had filed the appeal that the Nevada Tax Commission is now hearing on his responsible person determination. We have not heard anything today from Mr. Tapia why he is not the responsible person. As the commission and Mr. Chairman DeVold has identified, we've only heard issues relating back to the underlying audit and administrative law judge hearing. Those issues are now moot. The bankruptcy court dismissed the Chapter 13 petition filed by the Tapias on a motion to dismiss by the United States bankruptcy trustee. I think at this point, if Mr. Tapia wants to contest the issues of the underlying audit, his opportunity to do so has long since expired. And I submit that the motion to dismiss filed by the department has done so because this issue and these proceedings have continued to drag on without communication from the taxpayer until the very last minute, which is exemplified by today's hearing. So on that basis, the department would submit that the motion to dismiss should be granted, and Mr. Tapia can then deal with the department's revenue officers if he wishes to submit an offer in compromise.
Thank you, Mr. Keegan. Mr. Tapia, do you have a short comment?
Yes, many items of which there was mentioned about letters being sent. There were no questions, there were no documents or telling me that I had the opportunity to call him and that we needed an attorney. And so I did not have an attorney. I was going through the bankruptcy as what he was mentioning earlier. And so as far as being the responsible person, again, mine is back to the corporation is exactly the person who was doing the business. And as far as the items, I was referring to the items that got us here. meaning that how did the department come up that from $200,000, $2 million is now owed? And so that was my point going back on those. As far as, that time has come and gone, again, we're going around, like he had mentioned, it's been going on for a long time, and we're going around in a circle where those items have not been addressed by the state to show that specifically the vehicle that went to auction, because that's the major part of this conversation.
Well, I disagree. I don't think it's the major part of the conversation, Mr. Tapia. I think, we're looking at, are you the responsible party? And did you provide the documentation? And it looks like to me that you didn't do either. That you are the responsible party. You didn't supply the documentation. And kind of here's where we're heading is like, I'm going to support the department's denial of your appeal because I think you are the responsible party. But I would really support you getting with a revenue officer and getting an offer in compromise before you. We're really not prepared to talk about that because we don't have an offer in front of us. So if I could get your commitment to work with the department to get an offer and compromise in front of us, we would consider that and move forward. Does that sound acceptable?
I agree with submitting the offer and compromise because I believe that is going to be the next step in order to conclude this whole situation. I still feel that I am not the responsible party as far as on that, as far as not submitting the documents they requested. Again, each and every time they wanted new documentation of which that does not exist. But I do agree with submitting a offer and compromise.
Is there any other questions by any of the commissioners? Is there a motion?
Mr. Chairman, Commissioner Rigby, I would move to dismiss the taxpayer's appeal and uphold the administrative law judge's decision on the case of Jose Richard Tapia.
Commissioner Witt, second.
Okay, I've got a motion and second. All those in favor, please signify by saying aye.
Aye. Aye. Aye.
Anyone opposed? Okay, motion to dismiss taxpayers' appeal is upheld. Thank you, Mr. Tapia. Thank you, Mr. Keegan. Director Young, next item.
Thank you. The next item on the agenda is the taxpayers' appeal of an advisory opinion 20-006 dated March 12th, 2020. The first item under that agenda is an association. The department has Hillary Bunker available for questions, and there are several members, it appears, from the Vaping Association available. Thank you.
Okay, let's do this. Ms. Bunker, are you on the telephone?
I am.
Okay, would you mind giving us some background, and then Tina, if you would move to let each one of the individuals with the Nevada Vaping Association free up their telephone so that they can comment immediately after Ms. Bunker, that would be great.
Yes, we have Justin Townsend, Robert Solomon, and I believe David Van Sambeek.
Very good. Are each of you on the telephone? If you can just say yes for me quickly, we'll get to you in just a moment.
This is Justin Townsend. I'm here.
This is Rob Solomon. This is David Van Sambeek.
Very good. Ms. Bunker, go ahead.
Sure. This appeal stems from the Vape Association, and as you guys are likely aware, as of January 1st, 2020, vapor products were considered as part of the other tobacco products, or OTP, taxing and licensing scheme. And that was as a result of some legislative changes that were made last year. So the Vape Association reached out to the department and requested an advisory opinion on a couple of different broad areas in terms of licensing requirements, taxation requirements, refund requirements. That advisory opinion was issued this spring, and the Vaping Association has appealed it. The parties agree on some matters related to treating vapor products as OTP, but I would say the big categories that remain at issue are, the first one would be the definition and how the department is determining what is a component of a vapor product. The second category would be the licensing requirement for OTP wholesale dealers who are selling exclusively out of state but are housed in Nevada. And then I would say the third big category is related to products that is sold out of state by a second entity. So if you have an in-state wholesale dealer that sells product or transfers it to a retail dealer in state who subsequently sells product out of state. I believe that those are the three big categories, but if Mr. Townsend wants to elaborate on any of those, he can certainly feel free to.
Okay. Thank you, Ms. Bunker. Mr. Townsend, can you unmute your phone for me? There you go. Thank you.
Thank you, Chairman. This is Justin Townsend. I am an attorney with the Allison McKenzie Law Firm in Carson City, representing the Nevada Vaping Association in this appeal. I think Ms. Bunker has generally outlined the three issues that we believe are still at issue. Two of them are perhaps a little of greater importance to the association than the third. Just to summarize again what Ms. Bunker identified, we submitted a petition for advisory opinion containing a series of 11 questions related to legislation that was enacted in 2019 that modified certain provisions of NRS Chapter 370 related to OTP. We received the advisory opinion. There was also a follow-up letter that came after a conference by the parties and some legislators. The appeal, after briefing on the appeal, I think we have narrowed this down to a couple of primary issues. The first primary issue, and I realize I'm sort of repeating what Hillary said, but I kind of wanted to make sure that we're on the same page what the issues are. So the first issue we had identified, the first major issue, is based on a clarification from the department's brief that was submitted to the commission. The department clarified that when one wholesale dealer sells OTP to another wholesale dealer, and then that wholesale dealer sells the product out of state, that OTP is not subject or is exempt to taxation. But the department referred, and I think appropriately so, that the process for obtaining a refund for that OTP, if tax had been paid on it by the first wholesale dealer, the provisions of Nevada Administrative Code 370.165 would apply, and that provision allows only for a credit rather than a refund. The issue there being that there are wholesale dealers who sell most, and in some cases all, of their product out of state, and a tax credit isn't going to do them any good. So there's no provision in current regulation for a refund, and the credit process just doesn't work for those wholesale dealers who sell most or all of their product out of state. We had last week, and I know it was late in the game, but we submitted a proposal through Ms. Bunker, and I believe this may have been shared with some members of the commission as well, a proposal to amend or revise NAC 370.165 to address this situation by allowing a wholesale dealer to certify that its product is going to be sold out of state. All or a portion of its product would be sold out of state, and that they would not have to pay tax on the product that is so certified. And that would, we believe, alleviate burden on the department from having to collect monies that are ultimately not going to be owed and have to go through the credit issuing process. It would also free up the cash flow for the businesses that are engaged in this industry. And so we're hopeful that we can work with the department and perhaps modify the regulation in that way to resolve that first issue. The second major issue we have identified is the impact of the imposition of the tax on retailers, where the department has concluded that the tax scheme works a little bit differently than it does with transactions by and among more than one wholesale dealer, where the department there, as I had stated before, says that those transactions are exempt from taxation. A transaction where a wholesale dealer sells OTP to a retail dealer and then some or all of that product is sold by the retailer out of state, the department's determination is that there is no mechanism for refund or credit on the tax that wholesale dealer may have paid on that product. And we believe that there are some constitutional issues there that need to be addressed. And as 370.450, which is the statute that imposes the tax, imposes the tax upon receipt or possession of product by a wholesale dealer who receives and possesses it for sale or disposition in Nevada. The department's view of that phrase, for sale or disposition in Nevada, is based only on the very next transaction. After the wholesale dealer receives or possesses the OTP, if it sells it to a retailer in Nevada, the tax must be paid. Our view, and we think that this view is more in line with both state and federal constitutional law, is that the ultimate sale or disposition of the OTP is what really matters. If the OTP is not ultimately sold or disposed of in Nevada, but is sold or disposed of out of state, both state and federal constitutions conclude that the state cannot tax that product because it is an improper burden on interstate commerce. We cited several cases in our brief to support those contentions. The other, I guess, sub-issue related to the impact of this tax on retailers has to do with the equipment and how the department determines whether vaping equipment is subject to the tax. We had raised a couple of scenarios in our brief that we think make this determination somewhat problematic. There are, of course, vaping retailers who that's basically all they do is sell vaping equipment and products. But vaping equipment may be sold by other general retailers like big box stores, convenience stores. And just by way of example, the easiest example to think about is a battery. On a vaping retailer's shelf, you will find all kinds of vaping equipment, e-liquids, the vaporizer itself, the mouthpieces, and batteries, which power the vaporizer. Now, you go to a convenience store, you can buy the e-liquid. You can also buy batteries. Now, the batteries, they're obviously maybe used for any purpose, and it is unclear to us how the department will determine whether something like a battery is intended primarily for use as vaping equipment. And is it, whose intent are we looking at? Are we looking at the retailer's intent, the user's intent? And how is the department going to determine one or the other, depending on which way it comes down there? That's the issue with OTP equipment. The third issue is of lesser import, but still important, is the issue of licensing. Regarding the legislative intent of SB 263, which was the bill that made many of these changes, including the licensing requirement, the legislative intent was stated as follows. This bill is not about generating revenue, but reducing usage of vapor products in Nevada. It is our position that licensing of entities who sell exclusively out of state does not further this intent. And so our concern here is that there are wholesale dealers in Nevada who have a business location in Nevada, but sell exclusively outside of Nevada. And it does not compute, in our view, that those entities must needs be licensed in order to further the legislative intent of SB 263. Possession and must not be enough to trigger the licensing requirement. Instead, intent to sell or distribute for ultimate consumption in Nevada must be part of the consideration, excuse me. I also wanted to point out too, and I may have misunderstood, but in the department's brief to the commission, which I believe this was at page 7, the department erroneously states that licensing of wholesale dealers who sell exclusively out of state has been in place since 1997. And I don't believe that's accurate. I believe the licensing of wholesale dealers is a new requirement under the 2019 legislation. The statute that was created by SB 263 is NRS 370.567, and that is a brand new statute that imposes the licensing requirement on wholesale dealers. Regarding the suggested revision of NAC 370.165, going back to that provision may further be revised to encompass or to allow retailers who sell tax-paid OTP out of the state to seek a refund or credit of tax that is passed on to them pursuant to the existing credit memo process or some other mechanism. That's another issue that I think probably deserves some more exploration with the department. In conclusion, our position is that the department's position on these issues that have been identified violate the state and federal constitutions with respect to the taxation of interstate commerce. We believe the department is exceeding the authority given to it under NRS 370.450 in that tax and licensing must be limited to consumption of vapor products in Nevada. We believe that the department's opinion is arbitrary and capricious, constitutes arbitrary and capricious enforcement against traditional vape retailers versus general retailers like convenience stores. And we believe that the department's opinion constitutes arbitrary and capricious conclusions that sales by retailers out of state do not trigger the refund credit process where such sales by wholesalers do. Thank you.
Okay, thank you, Mr. Townsend. Ms. Bunker, do you have like a short rebuttal? I'm sure we've got lots of questions here on our side, so I'll allow you a couple of minutes for rebuttal, and same for Mr. Townsend.
Thank you. This is Hillary Bunker. I do have a short rebuttal, and I actually think on the first question, I may turn to the department, but I think that the parties are going to be in agreement on the credit versus refund issue. It's my understanding, and I'll allow someone from the excise unit to correct me, but it's my understanding that if a second wholesale dealer sold product out of state and somehow a credit was triggered, that could actually be turned into a refund. And I think we have somebody from the excise unit either on the phone or in Carson City. So would that be correct that the party would not be limited, the taxpayer would not be limited to a credit, that they could actually also convert that into a refund? Is that accurate?
This is Melanie Young, Executive Director. I believe we have Brandy Delaney that's going to be available for questions.
Ms. Delaney, are you on the telephone? If so, could you please respond?
Please dial *9 if you're on the telephone.
This is Brandy Delaney with the Nevada Department of Taxation. Last name is Delaney, and Hillary Bunker is correct. If there is a valid credit that is established on the account, then the wholesaler can request a refund and that will be processed.
Okay, thank you. So issue number 1 down. Would you agree?
Correct. I think.
Yeah.
Okay. Yes, I think that's going to be the easiest, so I wanted to get that out of the way. And I also think that to the extent the taxpayer has follow-up questions, there is actually statutory authority that allows for a refund if taxes have been erroneously collected. So this is not just something either that we're saying off the cuff. It is based in practice and in statute. So that, I believe, takes care of the credit versus refund. I think where the parties are not in alignment is really on the sale of product out of state. The department views the taxes, the OTP excise taxes are owed when an in-state wholesale dealer receives product for sale in this state. When the wholesale dealer subsequently sells that product to an in-state retail dealer, the taxable event has occurred. So at that point, what the retail dealer does with the product is not tied to the excise taxes that were owed. So to the extent the retail dealer sells the product out of state, sells the product in state, whatever they do with it, we're past the point of the excise tax that's been due because that's triggered based on the sale in the state. And I know that the taxpayers have raised that we should be looking at ultimately where the product lands, but this is a wholesale tax. And as such, the wholesale dealer pays that tax when they receive product, which is pursuant to the statutory authority. And what the commission should be aware of is that if the wholesale dealer that receives product sells that product themselves out of state, there would be no taxes owed on that. There would be no taxes due on that. So there is the opportunity for people within the tobacco supply chain to obtain a wholesale license and to sell that product themselves out of state. There's many people that do it that are housed in Nevada that receive product and sell it exclusively out of state. They do not owe the taxes on that, nor do they remit taxes. If for some reason they had paid taxes on receipt and subsequently sold that product out of state, they themselves would request a refund at that point because the product went out of state. The issue that we really have narrowed down is when the wholesaler is selling to a retailer and that retailer is selling out of state. There's just nothing in statute that would trigger a refund based on something that happened after that first sale. So I know that's absolutely a sticking point for the parties. And as far as the licensure occurs, although the statute number is different, and that was the 567 that Mr. Townsend was referring to, there have always been a statutory requirement for an OTP wholesale dealer that possesses product, and that's existed since 1997. In the brief, the other statutory sections are cited too. So again, although the statutory number may have changed, that's always been a requirement, whether you sell in-state or out of state, and the department has captured that by using terms like storing product or possessing product or receiving product. The licensure at that wholesale level has always been a requirement since the statutes came into existence. And then lastly, I think that there's going to be more discussion on the vapor products and the new terminology of whether the products are primarily or exclusively intended for use with a vapor product. And as Mr. Townsend mentioned, there's some clear-cut cases, but then you also have things like batteries and propylene glycol that are components potentially of vapor products, but maybe not intended primarily or exclusively to be used. So I would say that's a brief rebuttal. I envision there's going to be some questions though from the commission.
Yes, there will be. Thank you, Ms. Bunker. Mr. Townsend, do you have anything final wrap up before we start our question process?
Thank you, Chairman. Just one point on the credit versus refund. I appreciate Ms. Bunker and Ms. Delaney clarifying that issue for us. I think we would still propose a regulatory revision to ease the burden of both the department and also the cash flow of the business, where if a wholesaler is going to sell all of its product out of state, it's going to pay under the current scheme, it's going to pay the tax to the department, and then it's going to apply immediately for a refund. And so essentially the wholesaler and the department are just trading checks, and that doesn't seem to make sense from an efficiency standpoint. And so,
well, Mr. Townsend, I think probably what you need to do is that sounds like an administrative issue that I'm sure the Department of Taxation and the Vaping Association can work out. So I wouldn't spend too much time on that one. That seems like an administrative issue here.
Chairman DeVold, this is Tina Padovano. We have Mr. Solomon raising his hand, and also Brian Badera from the Nevada Vaping Association is also on the telephone, just so you know.
Okay, thank you. I'll let Mr. Townsend wrap up. It sounds like, I think we understand the issues here, and I'd like to get to the question period here, but go ahead, Mr. Townsend.
I didn't have anything else to say, but if Mr. Solomon or Mr. Badera have anything to add.
Mr. Solomon?
Yes, thank you. A couple of points, and really they're more a matter of clarification, and maybe to bring the somewhat abstract down to a specific. We understand, as Ms. Bunker indicated, that when an in-state wholesaler sells to another in-state wholesaler, and the second in-state wholesaler sells, whether it to a retailer or a wholesaler out of state, that the second wholesaler, in-state wholesaler who makes the sale out of state does not owe the tax. However, under the department's interpretation and administration currently, the first in-state wholesaler must pay the tax. And then we now understand that the first in-state wholesaler is entitled to a refund through a somewhat convoluted refund and delaying process. This is, as we've indicated in our briefing, this is a difficult situation, very expensive for the state to administer. The company that I work for, eSig Distributors, sells exclusively out of state. We have a large volume of sales, both purchases from in-state parties and sales out of state. Under the current framework, we would be required to provide, so first of all, the product that we get, that we purchase from the in-state wholesaler would have been subject to the tax. So the people that sold it to us would have paid the tax. We would then have taxed product. Presumably the price of our product is reflective of the tax that our seller paid. We sell the product out of state. We then go back to the people that we bought the product from and said, we certify to you that it has been sold out of state, and the party that sold it to us then has to apply for a refund. all of which it will be extremely expensive to administer from the department's perspective. There'll be thousands of invoices showing out-of-state sales that need to be reviewed. It's going to be an horribly cumbersome and administratively expensive process for the wholesaler who ultimately sells out of state, for the wholesaler who initially sold in the state, and for the department. And the proposal that the Nevada Vaping Association has made to the department is to simplify this whole process so as to allow effectively an offset at the time the product is sold initially in the state to avoid this, what is effectively a loan to the state of taxes with a subsequent recoupment.
Is there any other comment from the Nevada Vaping Association? Okay, let's bring it back to the commissioners. Are there any questions of staff or the taxpayers, specifically the Nevada Vaping Association?
Chairman DeVold, we may have lost Commissioner Rigby.
Yeah, I see that. I've sent her a text and asked her to hop back on, so I've got that. Yeah,
she
her
said that she
internet
lost
went
her
down.
internet connection.
I'm sorry.
She said that I apologize for interrupting. Commissioner Rigby has lost her internet connection, she indicated.
Yeah, she's dialing in by phone. So if Commissioner Rigby could raise her hand, Tina, you can give her those instructions.
Please dial *9.
While we're waiting, I have a question, Commissioner Lippman, for the record.
Please, go ahead.
This is just a business question and anyone can answer it. I'm wondering why some businesses are selling exclusively outside of Nevada.
Rob, you should probably answer that.
Yeah.
DJ.
Commissioner Lippman, this is David Van Sambeek for the record, VANSAMBEEK. When this legislation came to be and was proposed during the last session, we followed it very closely and tried to go out and get the ear of the legislators involved. We were unsuccessful in reaching everybody. Nevertheless, we're very familiar with a lot of the legislation. So on behalf of a number of wholesalers within the state, anybody that's decided to not sell in the state, it was a business decision, and it ended up being a very probably a good business decision, but for the fact that we need this clarity from the commission and the department on taxes going forward, which is to say, large distributors or wholesalers that are in the state, their Nevada sales may make up only a fraction, maybe 1% of their sales when they distribute or conduct wholesale activities through interstate commerce through all the other 49 states or even worldwide. The new legislation would have first imposed a floor tax on all inventory that you had on January 1st, 2020. For nice, easy, round numbers, if a wholesaler happened to have $1 million worth of inventory sitting on their floor on January 1st, they would have had to come up with $300,000 to pay the commission, even though only such a small chunk of all of their sales, maybe even 1%, end up getting taxed, and then they'd have to go back and claim a credit through the credit process at the time with the commission, if that commission, with the department. With that department credit would have taken maybe 30 days, 60 days, or even 90 days. It doesn't alleviate all the new inventory coming in on a month-by-month basis. If they had $1 million of turnover month by month, that's $300,000 every month. If it takes 90 days to get a credit effectuated for the first month on a rolling basis, a company could potentially have $900,000 sitting in float that they'd have to come up with that they can't use to go out and pay their Nevada citizens that are all employees, to cover other business expenses, and to conduct their operations. That was a big blocker for us, and a lot of companies that are doing business here in the States, in this state. So a lot of companies, e-cig distributors included, decided to, well before the effective date, go out and terminate that maybe 1% of their business, and not sell to people in Nevada anymore. Based on the fact that the legislators clearly stated, the primary draftsperson, Senator Reddy, clearly stated that the intent behind that both the wholesale tax and the accompanying licensing scheme were all to go out and prevent vaping through potentially raising the price for Nevada citizens on these products. A lot of companies made the business decision to go out and terminate that 1% of their business so that they wouldn't have to potentially provide hundreds of thousands of dollars that would just be in float in this continual payment and credit scenario. Does that help you answer your question, Commissioner Lippman?
Thank you. And so I think that was an important presentation. I appreciate it. Thank you.
And this is Hillary Bunker for the department. I would like to interject that taxes are not owed on products that is intended for sale out of state. So I know that Mr. Van Sandbeek has referenced paying the 30% OTP tax. That's only due on products that's going to be sold in the state, and the department has been very clear on that. So even though there was a floor stock tax, again, that's for products that's going to be sold in the state. So if there was a warehouse full of product to be sold in Nevada, then you would pay the 30% on that product. But if the product was not intended for sale in the state, then no OTP taxes are due on that. So I would like to make that clear, and the department still allows that on their tax returns, that if product is going out of state and it's received and it's identified as going out of state, you don't run into a credit refund situation because the wholesaler doesn't pay those taxes because they're not due. You only run into a credit or a refund if you don't identify where the product is going, or you hold on to it, you don't know what you're going to do with it, and then you subsequently sell it out of state. But the idea that companies would be selling product out of state and for some reason paying taxes on it when they receive it is incorrect.
Director Young, I think maybe I can help solve this issue. It looks like there's a number of complex issues. Some of them may need to go back to the Nevada legislature, that we cannot solve all of these problems today with this. So I'm recommending that you schedule a workshop with the Nevada Vaping Association and the Department of Taxation. Try and figure out where the biggest set of issues are. Let's try and do that as rapidly as possible. But it sounds like to me portions of these are being dealt with in Carson City and not through the Nevada Tax Commission. And I would suggest that maybe we send this back to a workshop. Let's see if we can get everybody kind of on the same page, and then bring those things back to us where you can't agree, and let's move forward. Does that sound acceptable?
Melanie Young, Executive Director for the Department of Taxation. For the record, yes, we will accept that.
Ms. Bunker, is that acceptable?
Yeah, I think so. I'm unclear with the process. Who would the workshop be in front of, like an interim legislative committee?
I would guess that Director Young would get the decision makers within the Department of Taxation, and then those, including Mr. Townsend, and whoever representatives that he has. It sounds like we could probably come up with some kind of a advisory opinion that works for both sides. But again, some of these sound like these are issues that need to be settled in Carson City, and we don't have the authority and power to correct some of these issues. Just based on what I've read from Senator Ratty's proposals. Would that be acceptable, Mr. Townsend?
I believe that would be acceptable to the association.
Thank you. So with that, could I entertain a motion to send this back to the department for a workshop within the near future and direct Executive Director Young to make that happen?
Commissioner Lippman, for the record, I move to take this matter regarding the Nevada Vaping Association, send it back to the Department of Taxation for further discussion and mediation among and between the parties, as the Executive Director deems appropriate.
Commissioner Bursey seconds.
I've got a motion and second. All those in favor?
Aye.
Aye.
Anyone opposed? Okay, very good. Thank you, Mr. Townsend, Solomon, and Mr. Van Sanpete. Thank you very much.
Thank you very much.
And also thank you, Hillary Bunker. We always appreciate your time. Executive Director Young, next item.
Thank you. For the record, Melanie Young, Executive Director for the Department of Taxation. Moving on to agenda item D, the consideration of the department's motion to dismiss the taxpayer's appeal and the taxpayer's appeal of the department's decision dated December 24th, 2019, pursuant to NRS 350.089, approving the Incline Village Improvement District (IVGIDS) installment purchase agreement for the purchase of 58 EasyGo gas-powered golf carts for the use at the Mountain Golf Course. This is Aaron L. Katz, and the department has Peter Keegan to present. Thank you.
Okay. Tina, can you make sure Mr. Katz is on the telephone, please?
Mr. Katz, can you hear us?
Yes, I can hear you. Can you hear me?
Okay. Okay, very good. Mr. Katz, I'm going to let you start. If you could make your presentation, if you could keep it to 20 minutes for me, please, I'd appreciate that, or less. That would be really appreciated. And then I'll let Mr. Keegan respond to your comments, and then give you one more chance to rebut any of those comments. So if you could keep your total presentation to below 20 minutes, that would be appreciated, sir.
Thank you for the opportunity, Chairperson.
You're welcome.
Why is the department here? Is it not to protect the public health, safety, and welfare of Nevada citizens? NRS 233B-038. Is it not to exercise general supervision and control over the entire revenue system of the state? NRS 360-200. Is it not to make decisions to ensure that the application of taxes in the state is done consistently among taxpayers and among various taxes? Why is the commission here? Is it not to oversee and give confidence to the public that the executive director is doing her job? Yet when it comes to ensuring that local governments are complying with the financial and financial reporting requirements of the NRS, the department and the executive director exhibit disinterest to the nth degree. This is what this appeal is about, in my opinion. I brought to the commission's attention the case of Builders Association of Northern California versus City of Reno. It makes clear that when it comes to possible remedies against local governments, only those established NRS 350, 354, 360, and 318 provisions provide the exclusive means. Thus, taxpayers in Incline Village who are being harmed in this instance must rely upon the department and the executive director to be their watchdogs and regulators of the entire revenue system of the state. That the executive director tells the public, we have no standing. Here she alleges appellant himself cannot identify a specific statutory or regulatory basis for this appeal, but instead asks the commission to read one into existence. But we all know this is not the truth. NRS 360-130 describes the executive director's duties, including the performance of other such duties as may be required. One of those other duties is set forth at NRS 350, which is to approve or disapprove local government resolutions to enter into installment purchase agreements. Since approval or disapproval is a decision made by the executive director pursuant to Title 12, i.e. NRS 360-130 and 360-245, instructs that all decisions of the executive director made pursuant to this title are final unless appealed to the Nevada Tax Commission, and any natural person who is aggrieved by such a decision has standing to appeal the decision. Notably, no exclusion is made for decisions made by the executive director pursuant to NRS 350-089. Thus, if this exclusion were intended, it should have been stated. And there's a maximum of statutory interpretation. My Latin isn't any good, but it's called casus omissus pro omisso habebendos est, which means a matter not covered by a statute should be treated as intentionally omitted. And that's what I suggest here. So when Mr. Keegan states appellant cannot identify a specific statutory or regulation basis for this appeal, he's wrong. Appellant has standing to appeal, not under NRS 350-089, but under NRS 360-245. Moreover, NRS 360-270 gives the commission broad power to exercise any necessary and proper power and authority, and that the enumeration of powers in NRS 360-200 to 265 inclusive shall not be considered as excluding the exercise of such powers and authority. So if there were any doubt as to the power and the authority of the commission to hear this appeal, broadly construing the provisions of NRS 360-245, clearly it does. Mr. Keegan points to NRS 350-089 as preventing appellant from appealing the executive director's approval of IVGID Resolution 1875 because it recognizes the local government's right to appeal denials. But that is not what the statute unambiguously says. According to Mr. Keegan, it's what the statute doesn't say. And again, I point to the maxim I just pointed to, that because it does not say the issue Mr. Keegan states it says, it was intentionally omitted. Here, the legislature could easily have precluded aggrieved taxpayers from appealing decisions such as this one to the commission. The fact it didn't means that the missing provision cannot be supplied by Mr. Keegan. It's called legislating, what the commission does not do. As to Mr. Keegan's assertion appellant has no standing because he was not served with an addressed copy of the decision, note that NRS 360-245-2 only speaks to the mode of service, i.e. personally or certified mail, and the time to appeal under either. Thus, service is not a prerequisite to the right to appeal. Rather, it is nothing more than a statute of limitations insofar as the time to appeal. Moreover, NAC 360-043 instructs that the provisions of NAC 360-043 to 200 inclusive shall be liberally construed to secure the just, speedy, and economical determination of all issues presented to the commission, or the department. NAC 360-172 identifies the required contents of a notice of appeal. Nowhere does it mandate that the person appealing must have been served with an addressed copy. Broadly construing the contents of notices of appeal, appellant's notice of appeal clearly complies. As to Mr. Keegan's assertion, appellant has no standing because he is not uniquely injured by the subject decision. The NRS 360-245 test is whether the appellant is a natural person or a legal entity who alleges he, she, it is aggrieved. Appellant meets this requirement. As to Mr. Keegan's assertion, the case of Schwartz versus Lopez mandates that appellant suffer some special or peculiar injury different from that sustained by the general public. Appellant has demonstrated that if Gibbs rec fee is not paid by all members of the general public, the only persons assessed are local property owners, and appellant is one of them. Therefore, appellant has suffered a special or peculiar injury. Moreover, footnote 5 in the Schwartz versus Lopez case instructs that we decline to consider the party's argument regarding whether plaintiffs have taxpayer standing because we conclude plaintiffs have standing under the public importance exception. Thus, the case did not determine there need be a public importance. Rather, appellant need only be an appropriate party, meaning there is no one else in a better position and he is capable of fully advocating his position. And I think I qualify. Now, the commissioner's decision conflicts with law. NRS 350-087 mandates that Resolution 1875 find that the public requires acquisition of these golf carts via an installment purchase agreement. But the resolution resolves no such finding. It states that the resolution must include a statement of the facts upon which the alleged requirement finding was based, but the resolution includes no such statement. The statute mandates that alternatively, there was no evidence presented that golf cart acquisition via installment purchase was required. This omission to state facts made any requirement finding arbitrary, capricious, and an abuse of discretion. In fact, to the contrary, there were 3 of the trustees who voted in favor of the resolution stated they would have voted in favor of acquisition whether or not it was on an installment purchase basis, and substantial evidence was adduced that a more than adequate excess fund balance existed which was available to pay for outright purchase. Although some on the IVGIT board stated the short-term savings of the installment purchase could be better spent elsewhere, they did not resolve upon what. And even if they did, there was no resolution adopted identifying what. The statute indicates there must be a statement that identifies each source of revenue of the local government anticipated to be used to repay the installment purchase agreement, but the resolution includes no such statement. Finally, the statute mandates that the resolution must include a statement that identifies the dollar amount anticipated to be available to repay the installment purchase agreement from each such source, but the resolution includes no such statement. Notwithstanding, the executive director failed to note these deficiencies, and she refused to consider evidence and arguments from an aggrieved taxpayer, which would have assisted her in identifying the deficiencies. Moreover, NRS 350-089 mandates that the executive director consider IVGIT's tax structure, but she did not, because if she had, she would have never have approved this resolution. Specifically, taxing local property owners for golf courses, nor use of a special revenue fund revenues on a major capital improvement purchase when NRS 354-570 expressly instructs such revenues cannot be used for those kinds of purchases. The statute also mandates that the executive director find compliance with applicable provisions of law. In particular, the failure to use ad valorem taxes to pay this general obligation debt, and use of an invalid special tax against real property, which agrees property owners such as appellate. And this is an issue I want the commission to consider. According to IFGID, its rec fee is a standby service charge assessed against property for owners' mere availability and access to use recreational facilities that are just as available to be used by the general public and the world's tourists without being required to pay the tax. And to obscure the truth, IFGID staff intentionally called this tax a fee and engaged in the most unbelievable financial reporting machinations imaginable, all in violation of NRS. I want to put this tax in perspective to the commission so you can fully appreciate it. We're in a COVID pandemic. Nevada, like every other state in the unit, is suffering financially. Because it faces a $1 billion shortfall, the governor recently called a special session of the legislature to address it. But if what IFGID is doing is moral and lawful, all the legislature had to do was take a page from IFGID's playbook, and that is to assess every parcel in the state a standby service charge for the mere availability to access and use the public's facilities and services offered thereat, whether or not the property owner is securing any type of service. That is the legislature, the right to the governor's mansion, the right to the schools, the parks, and the libraries, and the office of the attorney general, and the tax commission, and city hall, and the jails, and the courts, and every other facility and service government provides. Forget about cost cutting or zero-based budgeting. Forget about ad valorem taxes, all parcels pay the state. Simply divide the financial shortfall by the number of parcels in the state, and voila, there is no financial crisis. And what's the limit on the special tax, which is not based upon assessed valuation? Nothing more than what is politically acceptable. Is this not a repulsive notion? Well, welcome to Incline Village, and welcome to your department and the executive director who just don't care. Since the executive director has failed to consider these factors and refused to consider the evidence and arguments that were presented, it's now before the tax commission. And NAC 36174 instructs that the department shall determine whether the appeal is likely to affect the revenue of a local government, and if so, it shall provide a copy of the notice of appeal to the governing body of each affected local government and notify each of the date of the hearing so it may intervene. So did the executive director notify IFGID? I did a public records request to find out if she did, and it turns out she didn't. Nor was IFGID informed it should not go forward with its installment purchase pending the outcome of this appeal. So it went ahead and entered into the installment purchase. Again, evidence that the department is nothing more than an accommodator for local government to the detriment of local citizens. So given NRS 36245 instructs the commission may reverse, affirm, modify any decision of the department that is appealed by a taxpayer, and here the executive director approved a resolution not in compliance with law, I ask that the commission reverse. Thank you very much.
Thank you, Mr. Katz. Mr. Keegan, do you have a short rebuttal, please?
Yes, thank you, Mr. Chairman. This is Peter Keegan, Keegan, on behalf of the Nevada Department of Taxation. We have submitted our motion to dismiss and our reply. Mr. Katz has thoroughly gone through the reply. The department stands on its summarization contained in the reply on the basis of the case law that's been decided recently by the Nevada Supreme Court identifying limits to appellate bodies, including this one, the Nevada Tax Commission, regarding the substantive appealability of certain disputes. Unless there is a statutory or regulatory provision that allows for individuals to make those appeals, it is not presumed that they are entitled to do so. Here, the issue, the approval by the department's director of the installment purchase agreement pursuant to NRS 350-089, the only provision contained therein specifically allows for the appeal by the local governing body. Mr. Katz made his grievance known to IFGID's public body during the meeting wherein Resolution 1875 was approved and submitted to the Department of Taxation. As Mr. Katz identified, members of the IFGID board vacillated back and forth and discussed the issue, but nevertheless approved it and submitted it to the department. Mr. Katz's grievance is generalized in nature because a fee is applied to every resident of the Incline Village General Improvement District. Moreover, there is no unique harm to Mr. Katz, which has been reviewed in various cases by the United States Supreme Court and our Nevada Supreme Court as not providing a particularized injury, which is the generally known basis for standing. Thus, Mr. Katz does not have standing because he is not uniquely suffering any injury. His distaste for the recreational facility fee and beach facility fee is unfortunate, and perhaps, is a purchaser when he bought into Incline Village General Improvement District as a resident, he could have evaluated that as part of his due process. He claims that there's no avenue for relief because the County Board of Equalization will only review assessed taxes, and this is a uniform fee. Again, that would render his avenue for relief with the board, the Incline General Improvement District Board. He says that he has been unable to convince them to develop an avenue for relief to appeal these beach facility fees and recreational facility fees. This is not the purview of the Department of Taxation. This is the purview of the local governing board. If Mr. Katz and a group of individuals that agree similarly feel that the process needs to be changed, they need to change the composition of their local governing board. They do not need to continue to raise the issue with the Nevada Department of Taxation. This issue in and of itself has partially been addressed in very litigious case that has gone all the way to the Nevada Supreme Court. Specifically, one of the provisions that Mr. Katz was bringing to the Nevada Supreme Court's attention was his disapproval of the fact that he could not seek a refund of the beach facility fee and the recreational facility fee. The Nevada Supreme Court upheld the Second Judicial District Court's determination, finding that he had to work through the existing channels, which again would render him and his avenue for relief with the Incline Village General Improvement District Board, not with the Nevada Department of Taxation. This is simply just a matter of Mr. Katz's frustration with the beach facility fee and recreational facility fee, but unfortunately this particular issue, the 58 E-Z-GO golf carts, is not the avenue for Mr. Katz to receive the relief which he is seeking. He does not have standing under the statute, the commonly known statutory construction.
This is the court reporter. Everyone looks frozen. I'm going to leave and come back in.
Yeah, Mr. Keegan, can you hold for just a moment until the court reporter comes back in? And if you don't mind, wrap it up a bit. I think we understand what the issue is very well. And yeah, maybe we can wait for the court reporter to come back in.
That's fine. Thank you, Mr. Chairman.
Thank you. Tina, could you let us know when the court reporter is back?
Yes. Yes, I will.
Mr. Chairman, I apologize for my phone if it came through. I thought I was on mute and I thought my phone was off.
Okay, thank you.
I will personally chastise myself all day.
Okay, well, I will avoid that then, since you're going to do it for me.
Thank you, sir.
You're welcome. Is the court reporter back on now?
No, not yet. Just one moment. Under attendees.
Hello.
Okay, Nicole is back on the phone or on the Zoom.
Okay, very good.
I'm here. I'm
Thank
sorry to
you.
interrupt. I'm sorry
Thank
to
you, Ms.
interrupt.
Hanson. Thank you,
Sure.
Ms. Hanson. Okay, so Mr. Keegan, did you have any wrap-up comments, or were you finished?
No, thank you, Mr. Chairman. I think I've made my point, and it's contained
Okay,
in our
thank
briefing.
Okay, thank you. And Mr. Katz, I think we understand the issue fairly well. Did you have any other wrap-up comments with maybe less than a minute?
Yes, I do. Thank you.
Please.
Mr. Keegan says that this fee is applied to every resident in Incline Village. He's absolutely wrong. It is selectively applied to local parcel owners only. And furthermore, the commission should look at NRS 361-445. The only tax against property permitted in this state is ad valorem, assessed by county assessors. This is not an ad valorem tax. It's impermissible. Every expense that IVGIT incurs adds to this rec fee. So this particular installment purchase adds to the rec fee. Finally, the case that I filed against IVGIT, Mr. Keegan refers to, bottom line, the court determined there is no remedy. What the remedy is to go to the Department of Taxation or for them to enforce the provisions of NRS 354 and NRS 318. That's why it's before the commission. If you deny any remedy, then there is no remedy at all. Thank you very much, and I hope the commission will put its foot down and tell the executive director to start treating the residents of Incline Village fairly. Thank you.
Thank you, Mr. Katz. Just so you know, I read the entirety of your documentation, and I also spent 4 hours watching the November 13th, 2019 IVGID board meeting. It was palatable to see the confrontation between the board members and members of the public. It's obviously something that has been brewing for a while. I think this election where you're going to be able to replace 3 of the 5 members of that board is kind of a referendum on whether they like the way things are or whether the residents do not like the way things are, because it looks like Mr. Dent and Ms. Schmitz are running for re-election. Yolanda Knack, Blaine Johnson, Michaela Tonking, and Frank Wright are running for election. And I was kind of surprised. You seem to be fairly engaged up there. I was curious why you did not run for one of those empty seats or available seats, Mr. Katz.
That's an interesting question. I am pointed to by staff and the board as a piñata. Everything that's wrong in Incline Village, they point to me. So the issue becomes me. It doesn't become the issues that we're talking about here. And by the way, I ran for the board some years ago and did not get enough support to survive the primary. So I'm not going to hit my head against the wall anymore. And by the way, I don't think that this election is going to solve the problem. You have to understand our voting scheme excludes 2/3 of local property owners because they're not local residents. So they have no say-so in who's a new trustee there. And that's part of the problem. There is no political avenue to pursue.
I see. And perhaps that is a legislative issue to correct that one if that's of your nature. But it seems like things have been boiling for quite a while, and some of the candidates support your positions. Like I say, I watched the entire 4 hours of that November 13th meeting, and it felt like to me that they made findings, they made reasonable judgments. They were working on a budget that was maybe not the best, and it looked like they didn't have a finance manager in place at that meeting to assist them. But I think that the decision-making process from the people that were on that board was I'm not going to say it was perfect, but I think they were attempting to do the best they could with the information that was available to them. So with that, I'll stop my commentary, and I appreciate your time and energy towards this matter, and I'll invite other commissioners to weigh in and ask questions. And any questions from any of the commissioners? It doesn't look like it. Is there a motion that one of the commissioners would like to put forward?
Rosalie Bordelev here with a quick comment.
Yes, Rosalie.
I believe there is a motion to dismiss on the table before hearing or deciding on the full appeal. And I would recommend that you maybe consider that first on any motion.
This is Commissioner Wren, Mr. Chairman. I would move to dismiss the taxpayer appeal.
Is there a second?
Commissioner, Chairman, I think Ms. Bordelev suggested that we take the motion first before the second. Maybe I've mistaken, and Rosalie can weigh in.
So Peter Keegan, on behalf of the department, has filed a motion to dismiss the appeal. And so if you were to grant the motion to dismiss, then you wouldn't be making a decision on the appeal itself. If you denied the motion to dismiss, then the next step would be to make a decision on the appeal itself.
Does everybody understand what the process is? Okay. I'm sorry, I've forgotten who the original motion was from, but would you like to amend your original motion?
This is Commissioner Wren. I thought I stated it right the first time, but maybe not. But it's the first action is the first line, and that would be to move to dismiss the taxpayer's appeal. Is that correct?
Okay. That's so. I'm sorry. Go ahead. Commissioner Lippman, did you second?
I second the motion to dismiss the taxpayer's appeal.
Okay, so if a vote in favor of dismissing the taxpayer's appeal would eliminate the need to hear the decision, the secondary decision. Is that correct, Ms. Bordelev?
Yes, if you're granting the motion to dismiss, which would be dismissing the whole thing, then yes, you wouldn't be needing to make a subsequent decision.
I see. Okay, so as long as everyone understands that an affirmative vote would stop all of the second portion of it. Okay, so is there I've got a motion and a second. Any other discussion on that item?
Commissioner, Chairman, can I just make one statement to make sure I'm clear?
Of course, yes. Commissioner Brown.
Thank you. So what I'm hearing then is we are going to, the motion on the table is to grant the department's motion to dismiss the taxpayer's appeal.
That's what I understand, yes.
Okay, thank you.
Any other questions? Okay. All those in favor, please signify by saying aye.
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 Aye. Aye.
Is there anyone opposed? Okay, hearing none, the department dismisses the taxpayer's appeal and we're completed. Thank you, Mr. Katz, for your time. I appreciate you.
And I thank the commission.
Thank you. Director Young, next item.
The next item on the agenda is the petition for reconsideration of the department's denial of exemption status for organizations created for religious, charitable, educational purposes pursuant to NRS 372.3261. The first item on this agenda is being removed from the agenda due to an incorrect notice of the meeting. So Miss Rodeo America will be postponed to a future meeting. So we will move on to item number 2, the Foundation for Women's Leadership and Empowerment. And the department has Andrea Nichols available.
Chairman DeVold, this is Tina Padavano. We have Scott Scherer and I believe Phyllis James on the telephone for the Foundation for Women's Leadership and Empowerment.
Okay, thank you very much. Ms. Nichols, go ahead and tell us about this, this particular item, please.
Thank you, Chairman, Commissioners. I hope you can hear me okay. This is an appeal of the department's denial of a request for exemption from sales and use tax, and the Foundation for Women's Leadership and Empowerment applied as either a charitable or educational association. The department found they didn't meet the definition of a charitable organization because they don't benefit a substantial and indefinite class, and they found that they don't meet the definition of an educational organization because they're not providing instruction and disseminating information on subjects beneficial to the community.
Thank you. Mr. Shearer or Ms. Griffith, do you have a comment, please?
Yes, thank you, Mr. Chairman. Can you hear me all right? This is Scott Shearer.
Yes, could you spell your last name for us, Mr. Shearer?
Certainly. My last name is spelled S-C-H-E-R-E-R. I am with Brownstein Hyatt Farber Schreck and appearing today on behalf of the Foundation for Women's Leadership and Empowerment. As mentioned, also appearing today on behalf of the foundation is Phyllis James, the President and Chief Executive Officer of the foundation. I have a brief argument, legal argument I'd like to present if that would be acceptable to you, Mr. Chairman.
Yes, please.
Thank you. In this appeal, we are seeking a determination from the Commission that the foundation is entitled to a tax exemption as a charitable or educational organization pursuant to NRS 372.3261. The criteria established in NRS 372.3261 control the question of whether the foundation is eligible for the exemption. Both NRS 372.326 and 372.3261 were adopted by the legislature during the 1995 legislative session. NRS 372.326, which grants the exemption for religious, charitable, and educational organizations, became effective on January 1, 1997, after having been approved by the voters at the 1996 general election. Pursuant to NRS 372.326, the legislature was required to establish standards for determining whether an organization is created for religious, charitable, or educational purposes. At the time of the election, the criteria set forth in NRS 372.3261 had already been adopted by the legislature. They were adopted together in 1995 and the 1995 session, when the matter was then placed on the ballot for the public's vote. So those criteria in NRS 372.3261 were essentially ratified by vote of the people. Because the people specifically delegated development of the appropriate standards to the legislature, it is not appropriate for the department to add standards that are not in the statute. To qualify as a charitable or educational organization, an organization must comply with the requirements of subsection 5 of NRS 372.3261. Those include that no part of the net earnings may inure to the benefit of any private person. The organization must be nonprofit, must not participate in political advocacy, and property sold to the organization for which the exemption is claimed must be used in furtherance of the purposes of the organization. The foundation clearly meets the requirement of subsection 5 as established by the Declaration of Phyllis A. James, which we submitted with our brief. And it does not sound as though the department is contesting whether the foundation meets those criteria. Having complied with those requirements to be a charitable organization, its sole or primary purpose must be, quote, must be to advance a public purpose, donate or render gratuitously or at a reduced rate a substantial portion of its services to persons who are the subjects of its charitable services and benefit a substantial and indefinite class of persons who are the legitimate subjects of charity, close quote. The foundation's mission is to provide affordable, educational, skills-based conferences and programs that inspire and equip women primarily, and men also, to perform at their highest level of human and professional excellence in leadership roles in their workplaces, communities, and society. Helping people achieve their full potential is clearly a public purpose. The foundation will be providing free programs through its Aspiring Women webinar series, will offer scholarships for the Women's Leadership Conference when it resumes in the future, and subsidizes the cost of the conference for all attendees. Therefore, it renders gratuitously or at a reduced rate all of its services. As explained in the foundation's brief, women in general, and particularly women of color, have historically been underserved in access to company learning and development programs, and particularly leadership training. Although women make up half the workforce, they make up only 38% of managers. The foundation's purpose is to help women develop the skills they need to effectively compete for and fill positions at all levels of management in all types of organizations. Moreover, while the foundation's focus is women, its programs are open to all who might benefit from the skills taught. Men have attended the Women's Leadership Conference in the past and are welcome to attend all of the foundation's programs in the future. People who may benefit from the skills training offered by the foundation are a substantial and indefinite class of persons who are the legitimate subjects of exactly the form of charity being offered by the foundation. Even if this commission is not convinced that the foundation is a charitable organization, however, there is no doubt that it qualifies as an educational organization under NRS 372.3261. As noted earlier, the foundation clearly complies with the requirements of subsection 5. Other than those requirements, the only other requirement is that the foundation provide instruction and disseminate information on subjects of benefit to the community. And I hear Ms. Nichols saying now is that the foundation's programs are not of benefit, the information they disseminate is not on subjects of benefit to the community, and we would strongly disagree. The skills and leadership training provided by the foundation are valuable in both big and small businesses, for employees and small business owners, professional employees and executives of nonprofit organizations, or volunteers providing services to their communities. There is simply no doubt that the foundation provides instruction and disseminates information on subjects beneficial to the community. In our brief, we laid out a number of the different programs that the foundation offers, both through its Aspiring Women webinars and through the Women's Leadership Conference. NRS 372.326 specifically states that the legislature and only the legislature shall establish the criteria for determining which charitable, educational, and religious organizations qualify for the exemption. NRS 372.3261 states that for purposes of the exemption, an organization is created for religious, charitable, or educational purposes if it complies with the provisions of that statute. The department's attempt to add a requirement that educational organizations provide instruction to the community as a whole is contrary to the plain language of the statute. I don't hear Ms. Nichols raising that issue today in her comments, but it was certainly raised in the department's brief, arguing that to be an educational institution, they must serve the community as a whole. Nothing in subsection 4 of NRS 372.3261 requires educational organizations to benefit a substantial and indefinite class of persons. That requirement applies only to charitable organizations. The cases cited by the department in their brief are from states that have different criteria for educational organizations or that judge charitable and educational organizations by the same criteria. This is not the case in Nevada. And even if this commission were to apply a criteria requiring that the educational programs benefit the community as a whole, that clearly is the case with the foundation's programs. This commission has granted exemptions to other organizations that benefit a narrower class of persons than does the foundation, including the Nevada Water Environment Association in 2018 and Nevada Bighorns Unlimited in 2019. For all of these reasons, we respectfully request that this commission determine that the foundation is exempt from sales and use taxes pursuant to NRS 372.326. We'd be happy to answer any questions.
Thank you, Mr. Scherer. Ms. Nichols, do you have a rebuttal?
Thank you, Chairman. I'm not sure I quite understand the argument. With respect to charitable organizations, they do have to benefit a substantial and indefinite class of persons that are the legitimate subjects of charity. I don't know that women in leadership are a legitimate subject of charity. And again, Mr. Scherer then says, well, that's different than an organization created for, there's a different requirement and a different standard for organizations created for educational purposes, which is true. They have to provide instruction and disseminate information on subjects beneficial to the community. And we've always defined that as the community as a whole. I don't know that the purpose of the statute is served by defining the community as women in leadership. To me, that's a small class of persons. And then this, what the exemption was requested for a leadership training that was going to occur in Las Vegas. And there was the previous one, I believe they charged $1,000 for it. I don't know that saying that they may provide some scholarships brings that into the realm of charitable. I would direct the commission to look at the quarterly statement of activity that was provided. It's page 38 of the exhibits attached to my brief. I'm not exactly sure what page it would be in the commission's materials. Generally, we do request a 12-month profit loss statement at the very least. So we're trying to base the approval and denial on a quarterly statement of activity that ended in September of 2019, which is almost a year ago. But if you look at the profit loss statement, there's not anything showing that a substantial part of the budget of this organization is going to charitable services. And again, I would kind of want to make the point when we're talking about a substantial and indefinite class of persons or the community. I don't know that we'd be having this conversation if this was an organization that was created for men's leadership and empowerment. The policy behind these types of that a tax exemption is really a subsidy, and the policy behind the subsidy is that the organization relieves the government of some burden. The government has no burden to provide leadership training to any particular class of persons. The government has a burden to provide basically K-12 education. And then the mission, again, it's skills-based conferences and programs that inspire women. And I'm reading this just from the materials that they submitted. And with that, I'd be happy to answer any questions.
Okay. Thank
Excuse
you.
me. Excuse me, may I?
Yes, I was going to ask, excuse me, could I have Phyllis James, the president of the organization, say a few things, please?
Yes, I would be happy to, and thank you for allowing me to speak, because I think that there are some fundamental misconceptions about what our organization is and what our objective is. We are a new nonprofit founded in May of 2019, and we are set up for the express goal of providing affordable educational programs that equip women generally, not just one class of women, including women of color and men from all walks of life who wish to develop or enhance their skills to assume leadership at all levels of our society. So I want to make it clear, our objective and our target audience is not just women who have achieved leadership. It is for all women, whether or not they have already achieved leadership, and it is open to men as well. And we want to have a special focus in addition to women and men who are people of color. And in my view, there is no valid question that women and persons of color have traditionally been underserved and underrepresented in programs that foster leadership training, which leads to the ability to compete for leadership roles across our institutions. That is my first point. Our programs are open to the general public. We are not a membership organization that limits our leadership training and development just to members. Our programming is not limited to only one sector of women, that is women executives, or any particular industry or business. We are open to all women in all business sectors, to nonprofits, to academia, to elected officials, whoever. The content of our leadership training is twofold. We provide examples of inspirational women who are role models for everyone. These are women of significant achievement who appeal to anyone who wants to aspire to a higher level of personal development or to achieve higher levels of professional accomplishment. Often these are women who have achieved tremendous success despite tremendous odds being placed in their pathways. And a good example of that would be Tarana Burke, who is the founder of the Me Too movement. Secondly, our Women's Leadership Conference workshops are designed to appeal to three different levels of persons. One are emerging leaders, who are people who aspire to leadership but have not achieved any leadership role, or people who are entry-level leaders at the lower ranks of leadership. Emerging executives is our second track. These are women who may lead some other leaders but who are still developing as leaders, and I would characterize them as lower to mid-level leaders or managers. The third track is women who've achieved executive leadership role. Most of the attendees of the Women's Leadership Conference, which, as we pointed out in the materials, has been going on for about 13 years here in Las Vegas, and the 14th conference would have been actually going on right now here in Las Vegas, but for the COVID-19 pandemic. Another point I'd like to make is the Women's Leadership Conference has traditionally had outreach to college students who are aspiring to achieve leadership in the professional roles that they are trying to prepare for. These local colleges being UNLV, CSN, and Nevada State College. So the last thing I'd like to mention is the affordability of the leadership training that we aspire to present. We did significant research on other conferences in the United States who provide the kind of 2-day conference that we do. It is not correct that the WLC Leadership Conference has ever charged an admission fee of $1,000 or more. In fact, in 2019, the highest registration fee for the conference was $550. And our aim is to keep our conference registration fee below $1,000, which is why we seek sponsorships and donations. In contrast, when we looked at conferences that are comparable, that provide the level of high quality leadership training that we provide, typically those conferences cost at least $1,500 to $3,000 in the case of the TED Women Conference and the Women's Leadership Conference provided by the Conference Board in New York City. So, and TED, as a matter of fact, has a level of registration that costs even $5,000. So regardless of the comparative that you're setting up here, the Women's Leadership Conference is a substantially reduced level of admission for conference attendees. And I would like to point out that our foundation is providing a webinar series that is due to commence on September 22nd. It's a 7-part series called Aspiring Women. And again, it's meant to provide general leadership training for anybody who'd like to attend. That will be a free webinar conference. It is advertised on our website, which is at www.fwle.org. So I just like to say that our leadership training is for anyone in the general public who would like to attend, but we definitely have a slant toward providing all women from all walks of life with the opportunity for leadership training. And it is open to men as well, because the leadership training we provide appeals to all types of leaders across society. So that is what I would like to impress upon the commissioners today.
Thank you, Ms. James. Appreciate your time. Is there any questions of
Mr. Chairman?
Yes,
is
I'm
Scott
sorry.
Scherer.
Yes.
I appreciate Ms. James kind of setting the facts out. I'd like to make, if I could, just two brief.
Could you please make it brief? I'd really appreciate it. Thank you.
Two things.
Very
Ms.
brief.
Nichols talked about needing to benefit the community as a whole. I would point out that that the statute allows educational organizations to provide athletic, cultural, or social activities for children, clearly not the community as a whole, provide displays or performances of visual or performing arts to the general public, but not everyone is a patron of the arts. So generally a narrower set of people that may be interested. And offer apprenticeship programs are also considered educational organizations. So all of those arguably attract a much narrower audience than what the foundation is suggesting here. Nothing in that list of recognized educational organizations suggests that the entire community has to take part for it to be considered of benefit to the community. And finally, there was a comment about it needs to relieve the government of a burden. That's one of the potential criteria in the definition of charitable organization in subsection 3B2. But you'll note at the end of B2, there is an or. So it could be any one of B1, 2, or 3. So to require that is in every case simply is not consistent with the statute. And with that, I'll conclude, Mr. Chairman. Thank you for the time.
Thank you, Mr. Scherer. Are there any questions of the department or any of the members, Ms. James or Mr. Scherer? Any questions?
Commissioner Lippman, for the record. So Ms. James, I applaud what you're doing. And as a CPA and a tax lawyer, I certainly appreciate us empowering women, because I think if we empower women, we empower men as well. And I see exactly what you're saying. It's not just current leaders, but it's future leaders. And we hope that everyone, all girls and boys in Nevada, become leaders. But when I look at the website that you cited, I see, I see that it's Foundation for Women's Economic Literacy. Is that the correct website?
No.
Oh, FWEL?
No, FWLE.
Oh, okay, I transposed it. So I guess my concern is Ms. Nichols raised that what you're doing in Nevada is conferences. And not surprisingly, that happens a lot, certainly pre-COVID, and many organizations across the country would want sales tax exemption for their annual conference in Las Vegas. And that's not what the purpose of this exemption is for. It's for people who are on the ground, who are in Nevada, empowering women on a regular basis. And I think we need that, and I would support that, but I don't see that that's what your organization is doing.
Well, okay, I'm not really sure I understand the question, because historically, the Women's Leadership Conference for 13 years now has been presented here in Las Vegas at one of the MGM Resorts properties. Now, it would be open to anybody in the U.S. who might want to come, but it has always been based here in Las Vegas.
Ms. James, is your primary office on South Rainbow Boulevard in Las Vegas?
Yes.
That's your corporate headquarters, and you've been there since May of last year?
Yes.
Thank you. Does that help?
I would note in response to that, again, Scott Scherer for the record, that the organization is a Nevada nonprofit corporation, number one, and number two, that to be a charitable organization, they must be operating in this state. So it couldn't just be anyone coming in from out of state who could claim the exemption.
Thank you, Mr. Scherer. Any other questions by any of the commissioners?
Yes, this is Commissioner Bursey. if there were a tax exemption category that were available to this taxpayer, I would lean toward the one set up for organizations created for educational purposes. But we go back to the same problem we have as to what the community is that the organization serves. And I'm having a problem with that. And this is probably a question to Ms. James. And thank you for participating. I was really interested in your comments, and mine would echo Commissioner Littman's. In the taxpayer's brief in our materials at about page 106, you indicate that you're serving or attempting to serve and reach out to the rank and file individual and lower management. And Ms. James also indicated that you're reaching out to students, which to me means that it's entry level, emerging leaders or the aspiring leaders. You've had 13 years, not you, because the organization was under the auspices of the MGM Foundation, but there's been 13 years experience with the conference. And I'm wondering if there have been any statistics that have been kept or numbers that would reflect how many people, men, women, among the attendees, the percentages of those attendees who could be identified as people who are emerging or aspiring leaders, as opposed to women who are already in leadership or men who are in leadership positions.
Unfortunately, we don't have any demographic studies or statistical studies that have been done of conference attendees who later went on to leadership positions. There are only anecdotal stories about from many women who have gone on to be promoted into leadership, but I could not give you any statistics on that.
I think I might not have phrased it properly. My question was, do you have any numbers or demographics as to the percentage of people who attended your conferences who were emerging leaders, aspiring leaders, as opposed to those already in leadership positions?
So yes, and our demographic profile is that most of the women who come to this conference are either in the emerging leader or emerging executives categories. The executive women category is a distinctly smaller cohort.
Can you, not to belabor this, but if you were to take a single conference and say there were a certain number of attendees, what would the percentages be? If you're able to do that.
Yeah, I don't have a precise percentage. For the last 3 years, the attendance has been approximately 1,400. That's an average for the last 3 years, 2017 through 2019. And I would say, based on what I understand, clearly at least 60% of the women who are coming are in the emerging leader or emerging executives category.
Okay, thank you. That was the type of answer I was looking for. And I'd like to suggest that if your fee for attending the conference hovers in the $1,000 range, I think you might be pricing some of those emerging people out of the market.
I'm sorry, I didn't hear what your last comment was.
Oh, the comment was that I appreciate your answer. Thank you. And that I would like to suggest that if your fee for attendance of the conference hovers around the $1,000 mark, that I think you might be pricing some of your, or many of your emerging or aspiring leaders out of the market.
Well, if I could respond to that, the registration fee for the Women's Leadership Conference has never been $1,000. The last year of the conference was 2019, and there were 3 price points for the registration fee. And I can quote you exactly what those were. The price points were $275 was the lowest point, which was early bird registration. The midpoint was $449, and the highest fee was $549. And in fact, until the 2020 conference was canceled because of COVID-19, the highest conference fee was going to be $675. We're very cognizant of the fact that people who are at the lower ranks of management cannot afford to pay the expensive conference fees that many women's conferences charge. You know, the prices that I quoted to you, that's why we're making a concerted effort to reach out for donations and sponsorships so that we can keep the conference registration fee at an affordable price.
Are there
Thank
any
you.
other
That
questions? I'm sorry.
pricing is-
I apologize, Commissioner Bursey. Were you finished?
I'm finished, yes.
Thank you. Any other comments or questions from any of the other commissioners?
Commissioner Wren.
Commissioner Wren?
Thank you. First of all, I think this is a big cause. I understand that you have the conferences, but I'm kind of looking for the meat of the things that we look for to make these exemptions work. Can you give me, excuse me, an example of scholarships that you've granted, charitable donations you've made, educational offerings at these conferences that you provide proof of attendance? What do these people actually get, and what are you actually doing?
So that's several questions. If you look on our website, www.fwle.org, there is a subpage from the Women's Leadership Conference that provides the record of charitable contributions that the Women's Leadership Conference has made to local charities here in the Las Vegas community after all conference costs have been paid. Organizations such as Safe Nest, I can't list them all now, but they are set out on the website. And so it's our goal to continue the tradition so that after we pay conference costs, we donate a portion of conference proceeds, if we have any left over after costs, to local charities here in this community that support women and girls. You also wanted to, what was the other aspect of your question?
Yeah, thank you, Mrs. James. Of course, I don't have time to go to your webpage, but that answers part of my question. But really, the crux of my question is, I think, do you provide educational scholarships to who or what, and what type of education do you actually provide that's a benefit to a portion of Nevadans?
So those two questions. First, I'll take the nature of the leadership education we provide. It is twofold. First, as I mentioned, part of the educational experience is to be exposed to role models of successful women who have achieved success over great odds. And I'll give as an example, we had the first woman to be appointed to coach in the NFL. She was with the Arizona Cardinals, I believe. We had a survivor of the genocide in Rwanda who survived by hiding out in a bathroom with 6 other women during the genocide. We've had Susie Orman to talk about how to manage your financial life. We've had Lisa Ling, we've had Soledad O'Brien. We've had women like that who've achieved a great deal despite being presented with great odds. On the leadership front, we provide educational workshops that are organized around specific leadership competencies, such as the ability to communicate well in different mediums. As we know, one of the critical aspects of leadership is being able to communicate effectively to different audiences. Another leadership competency is how to build productive teams. Most leaders have to lead other people, teams of varying sizes, ranging from a few people to a few hundred people, and maybe getting up to a few thousand people. So how do you lead other teams? How do you exercise authority over other team members? How do you lead as opposed to being a boss of other people? In addition, we have how do you navigate change and crisis as a leader? These are just examples of the kind of leadership skills that we provide to people who come to our conferences.
Commissioner Wren, maybe I could jump in there. I've got the website up. Between 2011 and 2019, donations were made to Shade Tree of Las Vegas. It affords 24-hour accessible, safe shelter to homeless and abused women and children. Seeds of Hope, that's Embracing Project, Center for Peace, the Rape Crisis Center dedicated to helping victims and those in jeopardy of human trafficking. Dress for Success, Southern Nevada Children First, and then there's several others. So anyway, it does appear, you know, I don't know what level they're supporting each one of those organizations, but it does appear that they're supporting some nonprofits. Is there other questions of the potential taxpayer or the staff?
Thank you, Chairman.
You're welcome. Okay, let's bring it back to the commission. Is there any conversation at this point? You know, I think I'm overly sensitive to making sure that underserved foundations and people that are trying to help ladies succeed, minorities succeed. I think I'm super. I don't know. I guess I'm very, very aware of all of that, and especially what's happening in the world today. I think that's one of those things where I feel like I could err on the side of supporting this, but that's just me. So I'd love to hear comments from other commissioners.
Chairman?
Like. Yes.
Yes, so this is Commissioner Lippman for the record. Now that I have the correct website, and I apologize for transposing the letters, but I'm looking at the website, and the website, what's important to me about what you're doing is you're providing a free 7-part series, which will explore a host of leadership challenges intensified by COVID-19. And when I look at the women who are presenting, many of whom are women of color who are working and who've been successful in Las Vegas, including many leaders in the hospitality industry, which is not surprising. So is it appropriate for me to make a motion then?
Please.
Yes, thank you. So I would like to make a motion to reverse the denial of the exemption status for the Foundation for Women's Leadership and Empowerment.
Is there a second?
Commissioner Brown, second.
Yeah, I've got a motion by Commissioner Lippman, seconded by Commissioner Brown. Any other discussion? All those in favor, please signify by saying aye.
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 Anyone opposed? Congratulations, Ms. James. Please continue your good work and use these dollars to help many more people succeed. Thank you for your time.
Thank you.
Mr. Chairman. Thank you, commissioners.
Thank you.
Thank you. Director Young.
Thank you. Again, Melanie Young for the record, Executive Director for the Department of Taxation. Moving on to agenda item 6, informational items. Item A under that is penalty and interest waivers granted by the department for sales and use tax, modified business tax, and excise tax. And item B, approval and denial of status log for organizations created for religious, charitable, and educational purposes. And if there are no questions, I will move on to, if the Commissioner Chairman agrees, I will move on to the briefing.
Yep, I don't see anybody asking anything on the informational items. Go ahead, next item. Briefing.
Awesome. So again, Melanie Young for the record, Director of the Department of Taxation. Would like to give a great big shout out to the staff who've worked behind the scenes on this commission meeting, particularly, and the hard work they've done to make sure the testing and, this being our first full tax commission meeting with a very full agenda. I want to thank them for the work that they do behind the scenes. Moving on to budget reductions. At a previous tax commission meeting, Commissioner Brown requested that I present the department's budget reductions that we were facing at this time. And so those budget reductions were implemented at the 31st 2020 special session. The department is faced with keeping vacant positions open through the end of this fiscal year, which is June 30, 2021. Some minor operating reductions and enable the department's modernization project. I will say that we were facing having to lay off about 20 employees and facing having to close the Henderson office. You may have heard about that. It was in the news. However, the department worked really closely with the governor's office, governor's finance office, and the legislature. And there were some changes to those budget reductions to save having to lay off any employees and closing the Henderson office. And we're very grateful for that. So we are also hopeful that the funding, that if funding is available, the department could resume its modernization project in the next biennium. I would like to discuss the passing of SB3 from the 31st special session, which does 3 things. 1, it temporarily accelerates the general fund portion of the net proceeds of minerals, meaning that in state fiscal year 21, the mines will make their normal net proceeds of minerals payment and will pay an estimated payment only for the general fund portion. The second part of that bill does not affect the department as it changes the distribution for 1 year for the basic government services tax. The third part, which I'm proud to announce, it implements a tax amnesty program for the department that will run for a 90-day period and has to conclude before June 30, 2021. The tax amnesty program will waive penalties and interest for any taxes, fees, or assessment collected by the department so long as the taxpayer, one, requests the relief, that the payment for the period is paid in full. Note that the tax amnesty is only for taxes due prior to the passage of SB3. This does not apply to those taxpayers who've entered into settlement agreements, an offer in compromise, or is being audited that they have not received a final determination. The dates of the amnesty will be conducted have yet to be determined. And there are several factors for this. One, we are working with our IT department to automate this in our tax system. The last time the department handled a tax amnesty was in 2008 and 2010. And that was a very manual process. And we don't want to have to put our department staff through that, nor taxpayers. So we're wanting to automate that process. And then the other factor is to consider is when businesses are allowed to reopen. We plan to perform a large outreach and communicate when this will be implemented. Our public information officer, Eden Collins, is working on a media plan to include videos, notices to taxpayers, and communications with associations such as the Taxpayers Association and the Retailers Association. Moving on to other exciting news, we are getting very close to being able to accept credit card payments. I mean, I know it's hard to believe in 2020, the department still does not accept credit cards. And currently, the department can only collect taxes, fees, and assessments via cash, check, or electronic transfer from the checking account. We anticipate this will go live this fall. So we're very excited to be able to provide another opportunity for our taxpayers to remit their taxes to the department. Moving on to just a brief update on the COVID-19 for the department. The department is continuing to work well through this pandemic, and the staff are working from the office, some at home, some with flexible schedules, and very few staff out on leave. We did open, as you may have received in a previous notice, we opened on June 1st by appointment only and following the strict protocols and guidance from the CDC and OSHA. Right now, all offices except the Grant Sawyer location is open by appointment, and there are still no walk-in services. We are continuing to work with taxpayers during this difficult time with extensions and communications about waiving penalties and interest. And that concludes my presentation, and I'm available for questions. Chairman, you're on mute.
Thank you. Any questions?
Yeah,
Okay.
I do, Mr. Chairman.
Yes.
Just a quick question.
Commissioner Brown.
Director Young, the credit card payment thing is interesting to me, and I guess what I'm curious about is the department going to be able to add an additional fee to those transactions to recoup the fee that they pay to the bank?
Yes, great question. Thank you for that, Commissioner Brown. The department is working with the state treasurer's office who created a new model. And under that model for collecting payments, a taxpayer will be required to pay a convenience fee, but the department will not have to collect nor remit that to the bank. What will happen is this will happen through our online portal, and fee will be calculated through the Wells Fargo process. They will pay the fee to Wells Fargo and pay the taxes to the department. It will be a seamless process. And so we're very excited about this opportunity to be able to have taxpayers an alternative for remitting taxes.
Great. So just to be clear, so the department's going to get 100% of the tax that they were due. Perfect. Thank you.
Yes.
Thank you.
Thank you.
Yeah, those rotten bankers always have their hands out, don't we? All right. Thank you, Director Young. Our next meeting is October the 5th. And at this point, I'd like to invite any public comment. Is there any public comment on the telephone? Please, *9. Do I have that right, Tina? Raise your hand.
Yes. Yes, it is. Correct. We do have a public comment.
Thank you.
6, you may speak now.
Phone number ending in 166, you may provide public comment now.
Phone number ending in 166, please dial *6 to unmute yourself. Phone number ending in 166, please dial *6 to unmute yourself.
Can you hear me now?
There you go. Perfect.
Okay. Barry Duncan, Barryduncan. Commissioners, Barry Duncan on behalf of the Nevada Taxpayers Association. We just have one brief comment today. On behalf of the association and its board, we were hoping at a future meeting that the commission and or the executive director would prepare a presentation on the bill draft request submitted on behalf of the department to the legislature for the 2021 regular session. Thank you.
Thank you. I'm sure Director Young can make that happen for you. Thank you.
Excellent. Thank you.
Comment? Yes, thank you. Any other public comment?
Yes, Deborah Lewis, you may unmute your phone by dialing *6.
Hello. Hi,
Lewis,
my
how
name
are
is
you?
Deborah Lewis. Hello. Is the meeting over now? I'm very confused.
Yes, this is public comment.
Yes, but my comment is that, sorry, I was asked to be on the phone. My number was called and nobody's brought up my case. I've
If
been
you
on
were
the
part
phone
of the
for 4.5 hours.
I'm sorry, if you were part of the consent agenda, the consent agenda in item 3 was approved. So if you're in part of that consent agenda, that item was approved hours ago.
Okay.
All right.
Okay, I guess I don't know. I don't understand any of this. Sorry. I just don't. I was asked because
What was your case? Help me out with that. Tell me what your case was.
Mr. Chairman,
Mr. Chairman, it's F9.
This is Adrienne Roberts Larson, if I may.
Please.
Thank you.
Ms. Lewis, you and I have talked on
Yes.
the phone. Myself or Randy Asbell will be reaching out to you here this afternoon, but your matter was on the consent calendar this morning and it was approved.
Okay, I thank you all so much.
Thank you.
Now I'm tired. Thank you.
Any other public
Thank you,
comment?
Thank you. Bye.
Any other public comment, Tina?
Yes. Phone number ending in 627, you may unmute your phone by dialing *6.
Hi, my name's Taylor Teschner. Kind of going along with the last woman's question, where do you find this addendum of approved items? Can you hear me?
Yes, we can. Shelley, I would imagine it's on the Department of Taxation website. So there's an agenda posted and you can look through that agenda item.
Gotcha. Okay.
Thank you.
Thank you.
You're welcome. Any other public comment?
This is Kayla Yost. I do not see any more public comment at this time.
Okay, very good. I think that wraps up our meeting. Is there any other items for future agendas from any of the commissioners? I think the only one, I think we set a world record today for the number of times the NRS was quoted today. So I'm excited to join the Guinness World Book of Records on that front. So with that, everyone, have a great rest of your week, and our meeting's adjourned. Thank you.
Thank you.
Bye-bye.
Thank you.
Thanks a lot.